Give it. We can't promise. You have seen the condition of the list. 125 bails, anti-bails today. They must be given priority. Motions. Give it.
On humble request, Lordship. On humble request, item number 146 of today's list. It's the first matter of bail in connection with appeal. Lordship, this matter I'm being led by Mr. Basu, Shekhar Kumar Basu and Mr. Antarikko Basu. Lordship, this matter was mentioned on Monday. It was listed at 61. So it may be taken up today at any time, Lordship. We have a scheduled.
We can't. We'll go serially. If today, if tomorrow, if it reaches, we'll take it up.
Tomorrow, Lordship, it's difficult because we are having a schedule.
We will see, sir. We'll see. We can't give any precedence. That won't be fair to the other matters.
I understand.
Yes, any more mentioning?
May I permit to mention one matter for correction, my lord?
Correction.
Yes, my lord.
What is the error?
Error is, my lord, it will be Mekiliganj PS.
Tomorrow, to be mentioned tomorrow.
Grateful, lord.
Yes,
My lord, for mandamus appeal.
give it. Yes, any other?
My lord, we are seeking permission to mention, my lord, difficulties are that along with my learned APP, my lord. The yesterday's lordship is item number 31, lordship. We understand your lordship have shown the total dissatisfaction and even disapproval in conducting the matter before the learned additional district trial court, learned additional district session judge, my lord. And your lordships have even deprecated, my lord, in a word of, with respect, my lord, incompetency and with regards to our integrity, my lord. My lord, in this extent, my lord, we understand after perusing the case diary and the materials available before your lordships. But lordship, the matter is little bit in otherwise, my lord. So, my lord, we humbly praise because already, because I have seen yesterday, even, my lord, through the YouTube, it was very, even the privilege in seeing the matter while your lordships even dictating the order, lordships. So, lordship, may we humbly request, let the matter appear as a to be mentioned because my learned friend is not here. Kindly these two parts, my lord.
When you say it is otherwise, what do you mean, Mr.?
Otherwise, my lord, the observation from my lords that the learned PP has not declared the hostile, my lord. Now, my lord, there are my lord 13 CSW, my lord. Out of 13, my lord, 4 have been examined, my lord, and even cross-examined. Even it has not been corroborated, the 161 statement, my lord. The reason behind these two, one CSW1 and CSW4, CSW4 was the victim, my lord. He has received the injury, my lord, and he has corroborated the entire fact. But with regards to CSW2 and 3, my lord, they were not even the witnessed the incident, my lord. They were the neighbors. After the incident, when there was a little bit of hue and cry, then they have visited. But, my lord, lordship, you know that how the 161 statement in some extent is prepared. I do not want to open my mouth in this regard, my lord. So this is the reason the learned prosecutor thought it not to declare in the hostile, because, my lord, kindly see, even during the period of hostility, my lord, your lordship knows very well the evidential value with regards to that, my lord.
So you want expunging the adverse remarks?
My lord, will be humbly, my lord, will be, because the fraternity, my lord. That will be. No. My lord,
File and listen, we cannot recall the order,
lordship,
but we can consider your anxiety.
my lord.
So you file an application, we can keep it on to be mentioned.
My lord. My lord, and
Or you want expunging of the adverse remarks against the PP, that much you want.
that much, and also, Lordship, if you see the dying declaration, Lordship, if you see the custodial trial, my lord, since long, my lord, kindly see the last order with
No,
the
you-
bail has been rejected.
You also want recall of the bail order?
My lord, kind to say that it is not a recalling, my lord. Would like to apprise your lordship. Lordship, thereafter you can also want to keep the same order. We don't mind. Lordship would like to
Mr.
place 2-3 documents.
Chaudhary, now that since we have already signed it and possibly it's on the server by now, file a 2-page application.
Lordship,
Whatever you want, we'll consider.
lordship, that.
File it and give the number. It will be listed tomorrow.
Can application. Lordship, as to be mentioned as lordship, as your lordship's convenience.
We will consider.
Lordship, grateful, much of it, lordship.
Lordship, may I have your lordship?
Yes.
Lordship, item, my lord's list 126.
One?
26.
Today's list.
Yes.
My lord, in this case, honorable coordinate bench had directed for CBI inquiry.
Exhumation of the body and
3 months' time was given to the agency. My lord, the investigation is still on.
3 months' time was given when?
Preliminary report আমরা submit করেছিলাম
One report has been already submitted.
তারপর ওটা written by
PG.
final এপ্রিল মাসে
For filing final report.
এপ্রিল
In the month
From
of April,
April.
the direction was issued and we
For
have.
complete the
on April, we
investigation.
have filed a preliminary.
You want this to be adjourned?
My lord, we want extension. We have to
extension of
revise
3 months
further
time
investigation.
9 soil report CSF and দিল্লিতে
Yes,
পাঠানো
once it is called on, then Mr. Mujumdar, let it be listed as to be mentioned tomorrow. Inform your other side, you are the other side.
সুমন
Who is for the,
সুমন শেয়ানবিশ is the petitioner
whoever it is,
Lots.
you inform that tomorrow this will be listed as to be mentioned, we'll consider,
lots
we'll look at the papers and.
lots
দিয়ে দিও কালকে to be mentioned.
Mention it will be there.
না নিয়ে নিল তো অটোমেটিক
দিয়ে দাও।
For judgment, item number 1.
Lordship, I'm for the respondent number 8 to 11.
But I'm there, Milad, for the
My
private
senior
respondent.
counsel is on video conference.
I'm there, Milad. I'm there, Milad. I'm not.
I'll show you.
The instant appeal is dismissed.
Obliged. Grateful to your lordship.
Mr. Dasgupta,
My lord.
of course, he will be obliged. You have to
Anyway,
respond.
Milad, I'm always obliged. Milad.
Next.
Obliged.
We always oblige, lordship. Even the order code, otherwise.
Yes, we are always obliged.
Hey.
My lord, kindly
Why is it appearing as to be mentioned?
My lord, kindly come to the, my lord, order page number 2, my lord. The second paragraph, my lord.
Yes,
My lord, probably a typographical mistake, my lord, 20,000, my lord. Kindly see, my lord. The registered sureties of 10,000 each, my lord.
It should be 10,000.
very well. Therefore, the order dated July 5, 2023, be corrected by substituting rupees 20,000 in the place instead of rupees 25,000 as the bond value. So let the correction be incorporated in the order dated such and such.
Yes, my lord.
As the bond amount, value.
Item number 3. Four. I am for the petition.
Court state,
I mean custody.
This for the state.
Lordship, I'm praying for a short Passover, Lordship.
Passover.
Item number 5. Item 5. Not to the.
not today.
Item number 6.
Lordship, in this, I am for the CBI, my lord. My lord, predicament that I am facing is today charges are being framed before the court below.
Petitioner is not there.
Petitioner, like,
What are you suggesting?
my lord, next circuit.
Because the petitioner is not represented. Stop.
Praying for short Passover. My senior counsel is in court number 2.
My lord, then, my lord, my prayer is that because the CD is being used in the court below for framing of charge against the petitioner as well.
Oh. আচ্ছা এটা লিখো না দেখো Mr. Mojumdar, learned DSG, submits that the case diary,
Lordship.
the relevant case diary is before the learned trial court where charge is scheduled to be framed today.
Lordship.
Today,
I am for the petitioner.
considered to frame na charge is scheduled to be considered today. CD is not available, sir.
My lord, the matter is languishing, my lord, from the day first, my lord.
Without
Is-
CD, how can?
How can we proceed without the CD?
My lord, last day, my lord, they have, my lord,
It is
confirmed that the city
line
has
with the
come.
line with the London trial court for consideration of charge.
My lord, there are some point, my lord, need to be, my lord, hard, my lord.
Without the CD, what point?
কালকে না বললে সিটি এসছে। My lord, the CD has come, but due to my lord charge frame, the CD has been returned.
Correct.
Without using the CD, we cannot.
You know,
My lord, may I intervene, my
considered
lord?
today.
Yes,
My lord, let it be posted on the next circuit. my lord.
Yes,
yes, that we are.
that is what we are doing.
Lordship.
Stop. As requested by him, let this matter be listed again before the next available circuit bench, fairly at the top.
Therefore, my lord.
Item number 7.
Lord, Sabir করবে।
I'm praying for short pass.
Two of them go together.
8.
May I please your lordship, I am for the petitioner's lordship. It was yesterday, it was possible, my lord.
Again,
He is in court number 2, my lord.
difficulty is that if it is Passover, it may be, there is every possibility that it will be adjourned for the day.
Short possible, my lord, he is court number 2.
All right.
To come from Darjeeling.
Yes, I know.
Lordship.
Yesterday also you come.
Yes, I have come.
Do one thing, then after 37, we'll take up the
Come back.
Passover matter.
Lordship.
After item number 37, we'll take up the password matter. Otherwise, it will be difficult for the learned counsel.
Yes.
Item number 9.
But I'm for the.
Yes, which for the petitioner?
I'm for the.
You, okay.
Yes.
My lordship, my lord, kindly have a look on page 7 of my lord application, page 7, my lord. My lord, I prayed for a my lord application for bail. My lord, that was heard on my lord 23rd of my lord June 2021, whereon my lord the coordinate bench of this honorable court, my lord, has directed my lord to my lord conclude the trial within a shortest possible time without granting unnecessary adjournment. My lord, that was passed, my lord, on 23rd of June 2021. My lord, thereafter, after passing of that solemn order, my lord, there was no substantial progress of trial. My lord, thereafter, my lord, I filed another application. That is page 9, my lord. So, and my lord, by this order also, that was my lord, 5th of January 2023. My lord,
For delivery of judgment.
for delivery of judgment, my lord, by this order, my lord, by after filing this application, my lord, the learned court was pleased to, my lord, frame a schedule for, my lord, conclude the trial. And my lord, this honorable court, the coordinate bench of this honorable court, my lord, reject the application, my lord, placing reliance on that schedule of, my lord, progress of trial. But till date, my lord, there is no progress of trial. Even this schedule has also been failed. My lord, I have been
Just a minute, just a minute.
my lordship.
20th February 2023 has been fixed for delivery of judgment. That was in the schedule.
That was also in schedule, my lord. But till date, my lord, there is no progress of trial, no evidence has been, my lord,
So
taken.
when this schedule has been prepared,
Lordship,
evidence was not completed.
evidence was not completed. My lord, kindly have a look on the order, my lord. My lord, the order dated 5th of January 2023.
Yes,
My lord, may I read it out, my lord?
setting out a detailed schedule of evidence. The dates mentioned are 9 to 12 January 2023 and further dates for examination argument 28th February 2023 has been fixed for delivery of judgment.
Lordship, but nothing has been done, my lord. Till date, my lord, it is, my lord, pending as a. Well,
How many witnesses, CS witnesses have been examined?
My lord, CS witness, my lord.
There can be
12, my lord.
Sir, there can be schedule of examinations of the charge sheeted witness.
Lordship.
How can there be a schedule of the schedule for delivery of
But
judgment?
my lord, the
My lord,
report that was, my lord, the report that was, my lord,
That was a mistake, my lord. Actually, my lord, if Malay goes to the order of the lower court, it was fixed on 19th May 2023 for evidence of doctor. And not only that, regarding the 164, the learned magistrate was also called for giving evidence.
How soon can it be concluded now?
My lord, sir,
Any material has come?
a 6-year girl was.
Any prima facie
my lord,
material
I have
has
been in
come?
Yes,
custody
my lord,
from
164 is there,
2020, my
everything
lord.
is there.
No, why you have not annexed the certified copy of the impugned, certified copy of the
My lord,
reposition?
6 months.
Then we can consider.
My lord, give me a liberty, my lord, to file a supplementary affidavit, my lord.
Yes. Before the next circuit then. আমরা তো ওইটাই অ্যাসেস করবো না এখানে আমরা প্রোগ্রেসের এসেছি কিনা ম্যাটেরিয়াল
Learned advocate for the petitioner says that in spite of 2 earlier orders of this court to conclude the trial at an early date, not much progress has been made. Stop. He has been in custody for about
My lord, 7th of my lord, September 2020, my lord.
since for about since September
7th of Kigel. He started on 2nd of October.
Since blank
Arrested on 7th of
My lord,
October.
I beg of you.
October 7, 2020. Stop. Paragraph on the request of learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit to bring on record further relevant material. Stop. Paragraph. Let the matter be listed again before the next available circuit bench. So in the meantime, let the supplementary affidavit be filed with advance copy to learned advocate for the state.
Get rid.
Item number 10.
May I please your lordship? In the earlier occasion, lordship, I am asked to submit the deposition, lordship.
What is the nature of offense, sir?
This
6 POCSO Act.
Lordship. Sir, please hand over the copy. Page number 2 in the cross examination, lordship. I'd like
The
to,
victim has been examined.
yes, lordship. 3 person has been already examined.
Who is the victim here? PW?
PW1, lordship. 17 years, lordship. And
Just a minute. So prior to the incident, alleged incident, she was married.
she was married, lordship, residing together, lordship. And they have,
She was married with another person.
no, with this boy, this accused.
With
only.
this person only.
Presently also, she has been residing in the house of this accused person only. She is 16 years and she was 16 years at the time of marriage. And boy was 18 years at the time of marriage. Romantic relationship, lordship. I'd like to read out the.
Is this the case where the de facto appeared? No.
No, it was not.
Yes, sir.
Yeah, absolutely.
In fact, 164 is sufficient.
Wednesday is an auspicious day.
What is your submission?
My lord, it's fact that she was 16 at the time of she has married. She has admitted that, and there's a child also. Now she has given the birth of a child also.
We have heard learned advocate for the petitioner, learned advocate for the state. We have also perused the entire materials of the case diary, including the examination of the accused, examination of the prosecution witnesses, charge sheet witness. No, prosecution, PwC. Examination of the prosecution witness as recorded. Stop. We find that in the deposition of PW1 within a victim guard, there is prima facie there is no much allegation as against the present accused petition. Except the fact that the present accused petitioner and the PW1 are the husband and wife, and they were married
Lordship.
prior to attainment of the majority of the victim.
Lordship.
Stop it. Such being the position, we are convinced that the present accused petitioner is successful in making out a case for obtaining an favorable order of bail. Stop. Accordingly, prayer for bail is allowed. It is as ordered that the present accused petitioner may find bail of rupees 5,000 with 2 registers share 2,500.
Apply.
Satisfaction.
See,
Which court?
special court.
Learned Judge Special Court within bracket POCSO Act.
Kalimpong.
Additional Session Judge Kalimpong
Lordship.
with a further condition that while on bail, the present accused petitioner shall appear before the learned trial court on each and every date of substantive hearing, subject to the provision of section 317 CRPC.
Obliged, Lords.
Item number 11.
Item number 11, I beg to appear on behalf of the petitioner, your lordship. Lordship, I am for the state. Lordship, I beg my sincere apology. Lordship, kindly make it not today.
Why?
Why?
Lordship, CD. Lordship,
CD is not here.
Lordship, Lordship.
CD not available.
Well, learned advocate for the state says that the case diary is not available. Paragraph. This circuit is coming to an end. So let this matter be placed before the next available circuit.
Your lordship, kindly make it day after tomorrow, your lordship.
How long in custody?
For more than 2 years, your lordship.
Will it be possible to collect the CD by tomorrow? Then make it not today.
Not today. Then only not today. Kichu likhte hobe. Please ensure the availability of the CD tomorrow.
Item number 12.
For the petition, my lordship, the matter was heard by your lordship on 6th June, 6th July, and another accused was enlarged on bail by your lordships. Because if we assume, not admitting, the version of the prosecution in the page number 2, both the present petitioner and his son are standing on the similar footing. Can you see the page number 2 or the version of the prosecution? If I assume, not admitting, both the persons are standing on the same footing, and after considering all the aspects, your lordships were pleased to enlarge one person on bail. So my humble submission before your lordship, on the basis of the law of parity, I may be favored with bail on any condition.
Oh, it is that municipal matter.
Municipal matter, your lordship.
Who are you?
I am the Arijit Ghosh, the retired clerk.
Oh.
Retired
Yes,
clerk
lordship.
Now, lordship, kindly see.
and the father of
Anirban Ghosh.
Anirban.
Yes.
Father of Anirban Ghosh. Now, kindly see your lordship. Before perusing CD,
Lots of property.
lordship, kindly see. Page number 10, kindly see of my application. The FIR was lost. Now, lordship, charge sheet has been filed. Lordship, now kindly see. In addition to that letter, I have relied upon one letter issued by the Jalpaiguri municipality to me. I am the victim of circumstances. How much? Kindly see.
What?
Huh?
Finding in the charge sheet that document?
No.
Your,
That the document.
your personal document.
No. That is not personal document. Documents issued by Jalpaiguri municipality to me in the reply of RTI. I can give you the document. Lordship, kindly see the documents which I have relied upon issued by the Jalpaiguri municipality to me in reply of my right to letter of RTI. The particular relevant portion is the paragraph number 3 and 4. Very relevant. I am nothing but a victim of circumstances, your lordship.
How do you submit that?
Lordship, because if I assume the story of the prosecution, I prepared those bills that was signed and countersigned by the designaries, and that was checked and verified by the finance officer. That has been mentioned in the reply of the RTI issued by the Jalpaiguri municipality. That is not my case. That is their case. Now kindly see, the 65 bills were seized during the course of investigation. And those bills were allegedly prepared by myself. Kindly see who signed and countersigned those. I am not eager to utter those names. The document itself says who signed and countersigned. Being a clerk, it is not possible for me. I prepared a bill, I signed a bill, and Treasury will pass those bills.
You involve your son.
That may be.
Of the bank.
That is your version. Now, so for the observation passed by his lordship,
That impact
you
over
have
the
said,
society, your lordship.
I and my son are the kingpin. Son is on bail. I have also retired from service.
Son has excess due to you as because you are that time post holder.
That is a,
And you engage your son.
wha-
Your son has no access to enter.
no,
in
no,
the-
no, no, kindly see your submission in the order sheet.
No, no,
Kindly
no, I
see.
have the documents.
No, kindly, what you have
What is
said.
your submission?
Lordships, first of all, these persons is the employee of particular corporation, municipal corporations, your lordships. And he engaged his son and sent his son to different persons. They are deprived more than 84 lakhs amount. And deprived, those are genuine pension holder, your lordships. Those are genuine pension holder.
That
And-
money has been diverted.
Yes, your lordships. Yes, your lordships. And he engaged his son to collect the persons in a fake account holder and doing all these things. And main, your lordships, it's a light imprisonment case, and such type of accused, if released on bail, your
Just a
lordship, highly after
Hard learned advocate for the
misappropriate the
petitioner,
fund of
advocate for
government,
the state
84.
at length. At the very outset, Mr. Bhumik, learned advocate for the petitioner, draws our attention to the order dated 6/7/2023 as passed in CRM within bracket DB number 371 of 2023, whereby and whereunder one charge sheeted co-accused person, being the son of the present accused petitioner, was enlarged on bail by this court. It is contended by Mr. Bhumik, learned advocate for the petitioner, that considering the fact that investigation has already been completed, and also considering the fact that the footing of the present accused petitioner is more or less similar with the accused already enlarged on bail in the aforementioned case, the instant application for bail may be considered favorable. Stop that. You are Mr. Sarkar.
Yes.
While opposing the prayer for bail, Mr. Sarkar, an advocate for the state, submits before this court that in course of investigation, sufficient materials have been collected to substantiate that the present accused petitioner, being the departmental employee of the municipality, has siphoned huge quantity of pension amount to other accounts. Full stop.
Fictitious account.
Other fictitious accounts. It is thus submitted that the footing of the present accused petitioner cannot be equated with the other charge sheeted co-accused persons who have been enlarged on bail. Stop para. We have considered the rival submissions of the contending parties. We have also perused the entire materials of the case diary. In our considered view, the present accused petitioner, being a departmental employee, though he has retired in the meantime, is the kingpin of the alleged offense, who has been alleged to have diverted money from the government exchequer to some fictitious accounts. Stop para. It is reported that trial has not yet been commenced.
No, warrant of arrest against other accused persons is still pending.
Sorry,
Warrant of arrest against 9 accused persons is still pending.
trial has not yet been commenced. Stop para. Such being the position, we are constrained to hold that the present accused petitioner has miserably failed to make out a case for obtaining a favorable order from this court. And accordingly, prayer for bail is refused at this stage.
Highly obliged to you. Gratefully.
Item number 13.
I beg to appear for the petition, Lordship. Lordship, allegation is under section 376 of the Indian Penal Code. In this case, Lordship, an FIR has been lodged after 5 days of the incident, alleging that the petitioner entered into the house of this lady, she is a married lady, and ravished her. And Lordship, there is a clear contradiction between the 164 statement of the victim lady and her mother-in-law. Kindly see that, Lordship.
What is the stage?
5 months, 23 days, I'm in custody, only charge sheet has been submitted, Lordship. 5 days delay, and there is no explanation for the delay, Lordship.
What do you say?
My lord is reading the 164. My lord, this accused petitioner entered this victim's house, my lord, and he committed forceful rape upon her. And my lord, the eyewitness is the mother-in-law. He stated that she saw this accused petitioner entering the room of the.
He's saying there's inconsistency between the statements of the victim and the mother-in-law.
There is inconsistent, but not inconsistent, my lord. But eyewitness at that time, lordship, the mother-in-law saw this accused, my lord, fleeing away from this house.
Lordship, the victim,
Page number 24 is the 164 of whom?
Page number 164 is the statement of the.
Page 24.
Page 24, my lord. Page 24 is statement of the victim, and page 27 is the statement of the mother-in-law.
Difficulty is this, both in the written complaint and 164. There are sufficient explanation with regard to the delay.
Lordship,
Because there was emails, the victim lady has subjected to email threat at your instance.
kindly
And he
see the
was
medical,
physically
kindly see the medical, it is said old rupture,
He's a married lady.
old rupture. And the mother-in-law says,
My lord, page 84.
Lordship, the mother-in-law says
No,
that.
sir, we are not inclined. You withdraw if you want.
Then Lordship, can be in next circuit.
No, what next? Circuit? After hearing for 5 minutes, next circuit.
Withdraw or
Not pressed.
not inclined.
Item number 14.
I'm for the petition. Lordship, in this case, initially the FIR was started under section 363 of the Indian Penal Code. Thereafter, charge sheet is submitted under section 6 of the POCSO Act, read with section 363 of the Indian Penal Code. I'm in custody for 5 years, 3 months, and 18 days, Lordship.
5 years.
Lordship.
Victim has been examined.
Lordship, only the victim has been examined.
Have you annexed that
No,
deposition?
that has not been.
How can we assess that? We considered the long detention, but we have to assess the evidence also,
It
no?
is with me, Lordship.
With you?
Yes.
Very good. Show us.
What is the age of the victim?
At
What
the
was
time
the
of
age?
it,
Yes.
14 years.
My lord, at the time.
And the petitioner is 21,
15 years.
29 years.
At that time.
At that time, my lord.
Out of 23 witness, only the victim has been examined, Lordship. As the victim is already examined, there is no scope for tampering with the evidence, Lordship.
My lord, according to my memo of evidence, my lord, the brief fact of the case is that it started on 7th of May 2023. This 23 matter.
No. This is 2018 matter.
18.
Yes.
Yes. Anything, yes.
Already.
The case was
5 years, 3
initiated.
You
months it was-
know which paragraph you have stated that you are behind the bar since
Lordship.
18, no, paragraph 5.
Paragraph 5.
Case was initiated under
26
section.
দিন আঠারো থেকে রয়েছে। 26/3/2018 was in custody.
Initiated under section 363 IPC. Stop. Charge sheet has been submitted under section 6
6 of the
of
Poxo
the
Act, read
POCSO
with
Act,
section.
read with section 363 IPC. Paragraph. The petitioner says that he has been falsely implicated. Stop. He is in custody for more than 5 years, 3 months. 5 years, 3 months. Stop. Only 1 out of 23 charge sheet witnesses, being the victim girl, has been examined. Stop. He should be released on bail on whatever conditions that this court may deem fit and proper. Paragraph. We have seen the material in the case diary. Stop. We have also seen the deposition of the victim girl, being the PW1. Stop. Paragraph. Since the victim girl has been examined and considering the long incarceration of the petitioner, comma, and on an overall and there being little chance of the trial coming to an end at an early date, comma, we are inclined to allow the petitioner's prayer for bail, but on stringent conditions.
It is ordered that the present application may find bail of rupees 5,000 with 2 registered secured like amount. Satisfaction that court with a further condition that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing, subject to the provision of section 317 CRPC. And we shall not cause any threat, intimidation, inducement, etc.
Keep clear.
5,000. অনেকদিন আটকে আছে। There must be some grace. There must be some grace with regard to the amount also. 5,000 is all right, no?
Evidently, our court officer is not happy. He wants more.
Item number 50.
But I don't know, 50, this is a POCSO case, my lord. My lord, DNA test, I have filed the application for DNA test, my lord. That was pending, my lord, before the learned court below. Kindly, my lord, give me direction, the learned court below, that application dispose of, my lord, thereafter this application, my lord, hard. Kindly make it next circuit, and my lord, I have prayed for the, my lord, kindly see the order
What
dated,
is
my
the
lord.
application?
Order dated 14 June 2023, I have annexed. But this is the, my lord, petition, my lord.
DNA test of the baby
Yes, my lord.
with you.
Yes.
Matching of DNA test
Yes,
with the
yes,
baby and you.
Yes, because I am disputing the, my lord, the fatherhood of the baby, my lord.
What was the age of the victim girl?
My lord, age of the victim girl is
17,
16.
16.
Hearing of the petition date 30th March 2023.
Yes.
For learned advocate for the petitioner and learned advocate. It is reported at the bar. It is submitted at the bar that one petitioned for DNA test dated 30th March 2023 is still pending before the learned trial court. Stop. It is submitted on behalf of the petitioner that for effective adjudication of the instant bail application, the said application dated 30th March 2023 as pending before the learned trial court is required to be disposed of first. Stop that. Learned advocate for the state, however, does not oppose such prayer. Stop that. Such being the position, let the matter be placed before the next available circuit bench. Stop. In the meantime, such and such court is hereby directed to dispose of the petition dated March 30, 2023 as filed by the accused petitioner regarding DNA test positively within a week from the date of communication of this order. Parties to act on the southern office of this order. Dispose of it. Fine. 24. Frequency বাড়িয়ে order হয়েছে 24. No, frequency has been increased. It's good for the law. And that will be for 2 weeks or 3 weeks. No, next cycle after a gap of 7 days.
Any good news for us?
No, not declare. We cannot declare. Maybe good news. And we are also happy for you.
Whatever, let's say we are.
No, we are still not happy. We may be happy.
But we
get trial court lawyers mainly. So what happens? They're saying na ghar ka na ghat ka. So if this continues, we can concentrate fully on private practice.
no. Listen, happiness is such a thing. If it is distributed, it does not diminish. It increases.
It increases. Item number 16.
I for the statement.
Lordship,
I'm not pressing this bill
I'm for the
application.
defect too. Last
I'm for
circuit
the
was
petition.
rejected.
Not pressing.
Not press rejected.
I'm for the defect. Lordship. Yes, too. Item number 17.
But this is also a POXO case, service is not complete, can make it next circuit.
Next circuit.
Item 18.
Lordship, I am for the petitioner.
Who is for the state, sir?
18.
All right, pass over. Oh. CD is available?
No, Lordship, Friday.
Friday not.
Not today, Lordship, then.
Tomorrow come back.
Lordship,
Let us
time may be best.
Yes. Not today.
Not today.
Grateful, Lord.
Item 19.
But in this case, my lord, I am for the petition, my lord. My lord, service has been affected, my lord. But I, in the course of the, my lord, I am filing this evidence.
Oxo.
Yes, your lordship. Service has been affected, my lord.
Service has been affected.
Yes, your lordship.
Track report is there.
Yes, tract report, my lord, the acknowledgement due, my lord.
Show us.
প্রথম লাইনটা করে দেবে। Upon the learned advocate for the petitioners undertaking to file affidavit of service in course of the day, the application is taken up for hearing.
But in this case, my lord, the petition before lordship is in custody, my lord, 836 is in custody, my lord. My lord, in this case,
What is the offense? Only 6.
my lord,
Oh,
section 6.
363, 365 and 6.
Yes, your lord. Initially, my lord, the kidnapping case was registered. What happened in this case, my lord? The petitioner, my lord, victim and her brother, my lord, want to buy a mobile phone from Sitalkuchi market, Kochibihar, my lord. Subsequently, the no
Sir,
mobile.
Siri, please, Siri.
Mobile phone was found in the market, my lord. They went to, my lord, the Mathabanga, and the Mathabanga, their choiceable mobile phone was not found, my lord. They went to, my lord, to Kolkata,
to buy a mobile phone, the victim, her brother, and the petitioner before lordship. The allegation, my lord, that they stayed there for 3 days, my lord.
Sir, the last circuit dismissed your application.
Yes, Lordship.
Yes, my lord. The
Yes,
836 days in custody, my lord.
That's-
My lord, 836 days in custody, my lord. Kindly consider this, my lord. My lord, kindly consider. He is in custody. 836 trial has not been commenced, my lord. My lord, my lord, medical report. Kindly see the medical report, my lord. Kindly see, my lord. There is no, my lord, physical, external, internal, no injury, my lord. I have annexed the medical report. Annex P3, my lord, page number 17.
What is the statement of the victim?
Lordship, there are two 164 statements. One is of the victim, Lordship, and another one is of her cousin, who was also taken away forcibly by this Lordship accused.
My lord, I
That
have
is Lordship,
annexed-
page 43 and 44, Lordship.
Then who is the victim?
Victim, page 44, Lordship.
My lord, I have annexed the copy also, my lord. My lord, page number 18.
So
And
one
20.
boy and two girls.
Lordship,
Petitioner,
yes, Lordship, the victim and her cousin, Lordship.
one.
No, one
They were-
boy and two girls went together.
No,
No,
my lord.
Lordship, one boy and one girl, Lordship, the victim and her cousin.
Victim and
They-
her brother, my lord.
Yes, Lordship.
My victim and her brother went for buy
As it
mobile
is.
phone. The petitioner before lordship, my lord.
This
The neighbor.
petitioner
Oh, page number 43
is
is of a male.
Lordship, the brother of the cousin of the victim, Lordship, where he has stated that this accused person, he took them to Kolkata, Lordship.
Wow.
My lord, kindly see
The
the, my lord.
allurement of purchasing mobiles, she was taken to Kolkata and
My lord, this is the allegation. My lord, kindly see the, my lord, medical report, page number 17. I have no internal, external, no injury, my lord. This is the only story, my lord.
sir, difficulty is this. The legislatures in their own wisdom has changed the definition of rape.
My lord, yes, lordship, my lord. My lord,
This is the
the
difficulty.
it is in custody, my lord.
What is the stage?
My lord, copy
Charge
are,
sheet
my
has
lord.
been submitted.
Copies are, my lord, no
No.
evidence, my lord.
Not inclined.
My lord, kindly, my lord, 836 days in custody, my lord. I have served the copy.
Sorry,
my lord.
let the trial begin. Sir. We'll pass an rejection order or you withdraw.
My lord, withdraw, my lord.
Withdraw. Not press dismissed.
Item number 20. Item 20 and 21, madam. I already start the new matter. Can you make it not today, madam?
Not today.
2021.
By one day you can serve.
I already start. Tax report showing on process, madam.
Okay, okay.
Within one day may happen. Item 22.
I'm calling for the petition.
66, it should be.
Worship, there are two matters, relating matters, item number 66 as well, 22 and
22 and 66.
My lord.
Same
Alright.
city.
No,
Arising out of the same PSK.
no, same cell, police station, but the incidents are different. It's a chain of incident.
PSK's numbers are different.
My-
Different, Lordship.
PS is same, but
Right.
PSK's numbers are
Case
different.
number is
My-
different.
my lord.
All right.
Well, let's kindly come to the charge sheet. I have annexed the charge sheet.
You are submitting in respect of 22 only.
My lord first. And your lordship kindly comes to column 12 and para 12.
What is the nature of offense?
354.
Only.
8
And
of
POCSO
October.
8.
Also is there also. No?
Well, it kindly comes to the charge sheet, para 12, sub para 12.
Para 12.
Date
Yes.
of incident, 28th of February 2022. FIR lodged after 7 days, that is 5th of March 2022.
You are showing
I-
annexure P2.
My lord,
Annexure P2.
my lord, the charge sheet
Yes.
kindly comes to
Column number 12.
12.
Particulars of the accused person, charge sheet.
My lord, and sub para 12, sub column 12, date of arrest. My lord,
Roman 12.
my lord,
Surrendered
I-
before the learned court on 31st March 2000, released on bail.
my lord. And
Bail was
thereafter,
cancelled, Accused was arrested again.
my lord, that is because the initiation of the other police station case, which is item number 66.
Why bail was cancelled?
The reason is I have been arrested.
Violation of condition of bail.
Lordship,
No,
Lordship.
no, please. Yeah.
Yes, yes.
My lord.
Yes.
No. Lordship, the sequence is that the allegation is that the petitioner went to the house of the de facto complainant and ravished the victim girl. Thereafter, the FIR was lodged.
Age of the girl, age of the girl.
She was 40 at that time.
Siri, please.
Lordship.
Allegation is
I went to the house of the de facto complainant when she was alone. I ravished her and she raised her voice. Hence, I fled away. I could not able to commit furthermore offense. After 7 days, the FIR was lodged. If your lordship kindly sees the deposition of the
what is the written complaint?
mother of the de facto complainant,
What is the written complaint?
sister of the de facto complainant,
Lordship,
And-
page 2.
and the judicial magistrate who recorded the statement of the victim under section 164 has been examined, where the de facto complainant has stated the cause of delay of lodging the FIR. It is that I called the family members of the petitioner to negotiate the matter, which could not happen. Hence, the FIR has been registered. And thereafter, upon knowing the FIR has been registered, the petitioner by its own surrendered before the learned court below and obtained the bail from that court.
In the first case,
My lord, 4 witnesses have been examined.
the
Out of-
allegation is in the first case of setting up fire.
Lord,
First case is that I molest her.
First case is required. What is the case number?
My lord,
PS case
PS case number is,
Lordship, 86.
86.
my lord,
Lordship. Yes, 86.
So it is not the first case.
Petitioner is.
You have handed over the wrong city, which is why I am confused.
I apologize, Lordship. This is the thing, Lordship. I apologize.
The দিয়েছে, কোন দিয়ে?
Written copy to the HMI.
Page number 8.
registration.
ওই সিডিটা
Vital witnesses have been examined. I did not disobey or I did not try to influence the witnesses because it is a long span I was on bail. I did not influence. Kindly see the depositions of the de facto complainant, mother of the de facto wife of the de facto complainant, sister of the de facto complainant, and the judicial magistrate who recorded the 164 statement of the victim.
Where will you?
I have handed over the copies.
De facto is the mother.
De facto is the father. He is the
Oh,
PW1.
Buria.
ঝরিয়া
Buria.
And the-
Where is the deposition of the victim?
Lordship,
Lordship,
At that time she died.
Lordship.
after that, what has happened? Now the item number 66 comes into picture.
Just a minute.
Madam,
When in the first case depositions were recorded,
madam,
we find parents and one sister of the de facto complainant, sister of the Victim girl has been examined.
My lord,
But
when
in
the
that
fact-
case, Vicky
no,
has not been
when-
examined.
When the victim supposed to be examined, she committed suicide.
I understand. Yes, what
And
is
the
your
other
con-
case has been started.
yes, what is your contention?
Now your lordship will find that the first conduct upon which the bail should be granted. The allegation against the petitioner, as per the deposition being made by the de facto complainant on law, that I'm a brother of an influential person in the locality, a Muslim.
Just a minute. On what count your bail was cancelled in this case?
I'm on that. When the victim has the item 66 comes into picture. The story is that two unknown person went to the house of the victim girl on
Give me this that
on
CD.
14th of April 2022. And threatened to unknown persons. FIR was started against present petitioner, brother of the petitioner, and two unknown persons. They threatened unknown persons. Victim committed suicide. When the case has been started on 14th of April 2022, on 15th of April 2022, I have been arrested. And subsequently, on 24th of April, 26th of April 2022, my bail was cancelled in the previous case.
Is there any dying declaration here?
Lordship,
There are dying declaration. And
Where is that?
Lordship, dying declaration, page 118. Page 118, Lordship. In Lordship, 136 case. Page 118, Lordship.
she categorically
Moinaguri PS 136.
Suicide note.
No, Lordship,
No, no,
she
no.
stated before the doctor, Lordship.
Doctor.
Yes, Lord, she was
survived for-
admitted with 65% of burn injury, Lordship.
She survived for 10 days. Lordship, there she stated that because of the earlier incident, two unknown persons come to my house, they threatened me, and I have committed suicide. No specific role of the petition. To the contrary, my brother and other two unknown persons, they have been enlarged on bail by this honorable court. I have annexed my.
Describes about the role of two unknown persons.
Now, Lordship, may I submit, Lordship?
And
Yes.
they are
We have understood you.
Lordship, this accused person was granted bail in Moinaguri PS 86, 2022, that is 8 POCSO. After that, Lordship, this accused, he started threatening the victim to withdraw the case.
Where are those?
Now, Lordship,
Where are those materials?
there are two statements, Lordship. That is page, Lordship, in Moinaguri PS 136, in that CD, Lordship, page 34. That is the statement of one grocery shopkeeper. And page 148,
Page 34.
34, Lordship. That is a statement of one shopkeeper. Independent witness, Lordship.
Yes, ma'am.
And Lordship, kind of bear me for 2 minutes, Lordship. Lordship,
Page number 34.
but 34, Lordship,
Is an
and
independent witness.
independent witness, Lordship. And Lordship, page 148 of the Lordship witness who saw the other co-accused persons, they were Lordship coming from the house of the deceased Lordship at 5:30 p.m.
Page number.
That is Lordship, page 148. Here, Lordship, this present petitioner, he conspired with the other accused persons. And in page 148, Lordship, the witness, he saw the other co-accused persons, they were coming out from the house of the deceased Lordship. And on the very next day, Lordship, the deceased, she set herself on fire, Lordship. And Lordship, after...
I have understood your case. Let us pass on.
Lordship, kindly bear me for 1 second, Lordship. Lordship, after Lordship, the day victim set herself on fire, Lordship, Lordship, the bail of this petitioner was cancelled on the ground that he threatened the victim. Section 305, Lordship. Lordship, my submission is, Lordship, children, they deserve a life. They deserve a life to spend with independence and out of fear and out of violence, Lordship. This victim, she could not bear the mental torture, Lordship. She was a 14 years girl, Lordship, and she committed suicide. Lordship, if this accused person, if he is granted bail, Lordship, again he will try to, Lordship, manipulate the other witnesses, Lordship.
We have heard you. We have heard you.
Grateful, Lordship.
We have heard learned advocate for the petitioner and learned advocate for the state.
Lordship, one matter was earlier rejected, Lordship, this 86 last month, Lordship.
At the very outset, learned advocate for the petitioner submits before this court that the 22 CRM 406 at the very outset, learned advocate for the petitioner submits before this court that the present accused petitioner has been constrained to file the instant application for bail since his bail application, since his previous bail as awarded in favor of him was cancelled on account of initiation of Moinaguri PS case number 136 of 2022, dated 14/4/2022. Full stop.
There was a rejection earlier by
Yes,
this court.
Lordship. Yes, Lordship.
Month of
Was there a rejection or not? We are
Lordship.
not asking the month. Where have you-
In the 66, item number 66.
Not in this one.
No. In item number 66.
Yes. Stop. It is contended by the present accused petitioner that considering the fact that the present accused petitioner has got no role in the alleged crime or in connection with Moinaguri PS case number 136 of 2022, dated 14/4/2022, the present accused petitioner may be enlarged on bail on any condition whatsoever, keeping in mind the nature of depositions of the prosecution witnesses as recorded in sessions within bracket POXO case number 30 of 2022, arising out of Moinaguri PS case number 86 of 2022, which have been annexed with the instant application for bail.
It's not an ex.
Oh, which have been photocopies of which have been handed over to us in course of hearing. Stop there. While opposing the prayer for bail of the present accused petitioner, learned advocate for the state requested us to peruse the case diary of Moinaguri PS case number 86 of 2022, as well as Moinaguri PS case number 136 of 2022 conjointly. It is submitted that after commission of the alleged crime in connection with Moinaguri PS case number 86 of 2022, the present accused petitioner as well as his associates mounted pressure upon the victim, which is why she had found no other alternative but to commit suicide, for which Moinaguri PS case number 136 of 2022. Stop. It is further submitted by her that in the event the present accused petitioner is enlarged on bail, especially in a POCSO case, a wrong message would go to the society. Stop. We have duly considered the submissions of the learned advocates for the contending parties. We have also perused the entire materials of the case diaries in connection with the aforementioned two PS cases. Stop. We have also gone through the depositions of the prosecution witnesses as recorded so far in sessions within bracket POCSO case number 30 of 2022. Stop. We have also perused one dying declaration of the victim, one dying declaration of the deceased as recorded in connection with Moinaguri PS case number 136 of 2022, who happens to be the victim of Moinaguri PS case number 86 of 2022. Stop. It appears to us that in such dying declaration, we do not find any role of the present accused petitioner, at least prima facie. Learned advocate for the state, in course of her submission, draws attention of this court to the statements of the two independent witnesses regarding the complicity of the present accused in the alleged crime of Moinaguri PS case number 136 of 2022. But in our considered view, those statements prima facie appear to be very remote. Stop. Considering the entire circumstances, considering the entire circumstances, and also considering the fact that trial of this case has been progressed for to a considerable length, we are inclined to allow the prayer for bail of the present accused petitioner with some stringent condition. 20,000 with two registered 10,000 each. Satisfaction POCSO court on condition that the present accused petitioner shall not leave the territorial jurisdiction of the learned trial court unless permitted by the learned trial court, and shall appear before the learned trial court on each and every date of substantive hearing only, no 17/3/17. He has to appear, disposed of. এবারে 66টা নিয়ে নিন, ফাইলটা দিয়ে দিন। Our learned advocate for the petitioner and learned advocate for the state at length. We have perused the entire materials of the case diary, including the written complaint, comma, the relevant statements of the witnesses recorded under section 161 CRPC, and the dying declaration of the deceased. Stop. We consider that the present accused petitioner is successful in making out a case for obtaining a favorable order. What is the stage, ma'am?
Lordship, trial is going on.
No. Second case.
Oh, second.
Second case, charge, charge has been framed. Charge has to be framed.
It is as ordered that the present accused petitioner may find bail or rupees
Charge has been framed.
10,000 with 2 registers your like amount. Satisfaction.
It's
Same court.
No.
No,
It's
Lordship.
a additional district and session judge, third special court, Jalpaiguri.
ওটা লিখে নেবে না? Additional session judge, third special court, Jalpaiguri. With the further condition that the present accused petitioner shall not leave the territorial jurisdiction of the learned trial court till conclusion of the trial unless permitted by the learned trial court, and he shall appear before the learned trial court on each date of substantive hearing subject to the provision of section 317 CRPC. Would it not be better to
Instead of not to leave, not to enter the jurisdiction of the local police station.
No, it's all
Police
right.
station, that.
it will only be able to, it should be tried by this one court.
No, it won't be until and unless that's a POXO court. And now there will be an application by the state. State has not moved any application for that.
No, POXO court is not depart from taking
That's
any
true.
other case also.
They are having the same jurisdiction, additional session judge, but then there'll be a application to that effect by the state. Grateful, Lordship.
Malad, I am for the petition. But offense under section. Malad, offense under section 341, 323, 379, 506, 34 of the Indian Penal Code and A to section 25 and 27 of the.
So 379 and 25, 27 arms are non-bailable.
Yes, Malad. Malad, petitioner is not the FIR named accused. And Malad, allegation is that the de facto complaint went to the bazaar for buying some grocery goods. At that time, the accused person, Malad, restrained him and assaulted him with fist and blows. And Malad, taken away cash of rupees 12,000. And this petitioner.
Is there any material?
Yes, my lord.
Malad, this Malad, may I submit?
Placing gun upon the head.
Malad, this petitioner, Malad, shown arrest on 31st of May, Malad.
All right.
Just Malad, yes, I am the political person and very case was pending, Malad. And all cases are granted against the order, Malad.
Allow us. The allegation is that the petitioner, along with other accused persons, intercepted the victim while he was returning from market and snatched a sum of rupees 12,000 from him. Stop. Paragraph. The petitioner says that the allegations are completely false. Stop. This is the complaint is the result of a political vendetta.
Yes, Malad.
Stop. Paragraph. You are in custody since
But 31st of May, Malad.
this year.
Malad, yes, 42 days, Malad.
Paragraph.
No.
Charge sheet.
Not correct.
Investigation has been progressed for a considerable.
We have seen the material in the case record, case diary, including statements of witnesses. Stop. Investigation has progressed substantially. Stop. Paragraph. On an overall assessment of the nature and gravity of the offense and the material on record, comma, we are of the view that further custodial detention of the petitioner may not be necessary. Paragraph, so necessary, comma, so long as he cooperates with the investigating officer. Paragraph.
10,000, 5,000 with 2 days of 2,500 each. And to subject to the satisfaction of learned ACGM Dinhata District Kuchbihar.
Yes.
With the further condition that the present accused petitioner shall meet the investigating officer of this case as and when called for till submission in final form.
24, for the petitioner, Your Lordship. Lordship, this is a renewal of prayer for bail. Last occasion, I got the opportunity to renew my prayer for bail after adducing the evidence of victim and the doctor. Now, kindly see, Your Lordship, the page number 17.
So last rejection, sir.
Last rejection in last month. And that was, kindly see, Your Lordship.
Have you annexed that order?
Lordship, page number 23. 24 is the relevant. Second paragraph. In view, comments.
So after completion of examination of the victim and the medical officer, you are renewing the.
I am renewing the prayer. That
Have
is
you
my
annexed?
submission.
Have you annexed that?
Lordship, the page number 17, kindly see. Kindly see the page number 17. The girl is 16 years old at that time. I was 20 years old. Both are co-villagers. They have intimacy. Now, that may be reflected in the deposition. Kindly see. Kindly see, Your Lordship, the relevant portion, the third paragraph, commencing on the next day morning. On the next day morning, when the alleged victim returned to her home, she, with me, she revealed her mother that she spent her night at a female friend's house. And why the case has been initiated? That has been also been mentioned by the VG herself. After a lapse of 3 days, she sustained some stomach pain.
দেখুন পেজ নাম্বার 17, 18, 19.
That is a clear case of romantic relationship which was subsequently under pressure converted into a shower.
Page 32 is the 164 statement, Lordship.
It has lost its significance because now deposition has been completed.
Lordship.
Our learned advocate for the petitioner, learned advocate for the state. Stop. At the very outset, learned advocate for the petitioner draws our attention to the order dated 5/6/2023 as passed in CRM DB 233 of 2023, whereby and whereunder a liberty was given to the present accused petitioner to renew his prayer for bail after completion of the examination of the victim and the medical officer. Stop. It is contended that from page number 17 to page number 21 of the instant bail application, it would reveal that the victim girl and the medical officer has already been examined. Stop. It is contended that considering the fact that the present accused petitioner is languishing in JC since
482 days, Your Lordship. That means
since
Your Lordship, I'm saying
gap
15th March 2022.
the present application for bail may be considered favorable. Stop. While opposing the prayer for bail, learned advocate for the state draws our attention to the statement of the victim as recorded under section 164 vis-a-vis the deposition of the victim girl as recorded by the learned trial court. It is contended by her that considering the parity of the evidence and the statement, the instant application for bail may be refused. Stop. We have considered the entire materials as placed before us. Admittedly, there are sufficient incriminating materials as against the present accused petitioner in the deposition of the PW1 being the victim girl. However, considering the fact that the present accused petitioner is languishing in JC for a considerable length of time, and considering the fact that learned trial court has already recorded the deposition of the victim girl, were inclined to allow the prayer for bail with some stringent condition. It is thus ordered that the present accused petitioner may find bail out rupees 10,000 with 2 registered security like amount, satisfaction,
The learned
spaces,
special code, POXO
learned-
Act, Jalpaiguri.
learned, বলে দিন,
Special code POXO Act, Jalpaiguri.
with a further condition that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing, subject to the provision of section 370 CRPC, and that he shall not leave the territorial jurisdiction of the learned trial court until further order, unless the such condition has been relaxed by the learned trial court, with a further condition that the present accused petitioner, you belong to the same locality,
Lordship.
girl and boy.
Co-villagers, we are.
Yes.
We may be permitted not to enter that
ওই আরেকটা লিখে
jurisdiction
দেবে যে ওই
if your lordship desires.
shall not commit threat, inducement or
Lordship, I will, lordship.
ওটা যেমন আছে সেটা।
Deeply grateful, your lordship.
Item number 25. I am for the petition.
Plus 25. Plus 1 day accommodation, CD not produced.
26. CD is not. 27.
Your Lordship, I am for the petitioner, praying for not.
28. 26. I am for the state.
Well, the 26, I'm for the statement.
Not today. Somebody has prayed for not today.
28.
I'm for the state lordship.
Petitioner, pass over.
29.
State. Who is for the state, sir? Pass over.
30.
Pass over.
31.
What happened? Who is for the state?
30 maybe not today.
31.
Lordship, I am for the 30.
31, 30 not today.
30 not today.
All right. 30 not today.
31. 31?
31.
Yes.
Not to the lordship.
Series not available.
Cholo.
Next.
32. Yes.
Who is for the state, sir?
I'm on behalf of the petitioner.
Pass
State,
over.
state. Pass over.
33.
Petitioner. Both sides are present. Yes. We'll take.
Lordship, only on the grounds of non-compliance of 41B, relying the observation part of the lordship of the yes, I am praying for bail.
What observation?
And the violation of the observation part of the Honorable Supreme Court in the DK Basu's case. Only one point I am for the one point I am something, because observed by lordship on yesterday.
Arrest memo, no independent
No,
witness.
Column 10 is lying vacant here.
Vacant.
Page 5. Page 5.
Why do you do this? Why do you, not you, your officers? Admittedly, commercial quantity of contraband items was recovered from the possession of the petitioner. Stop. However, the petitioner says that the memo of arrest is irregular. Stop. There is no signature of independent person against column number 10 of the memo of arrest. Stop. This is a mandatory requirement as pronounced by the Honorable Supreme Court in the case of D.K. Basu, etc. 1997. The citation.
Provide the citation.
Section 42B, 41B.
41B.
41B, capital B. CRPC also mandates that memo of arrest shall be witnessed by an independent person. Stop. This is a gross illegality which entitles the petitioner to bail. Paragraph. We have seen the case diary. We have to see the material in the case diary, including the arrest memo. Stop. Indeed, the column number 10 is empty. Stop. Paragraph. Accordingly, we are constrained to hold that the petitioner has been able to overcome the restriction in section 37 of the NDPS Act. Stop. We therefore allow the petitioner's prayer for bail. How long in custody?
I am in custody of Lordship.
Charge sheet?
Charge sheet filed 6th May 2022.
22.
Charge sheet filed
Comma the
October 2022.
also considering that charge sheet has been filed after completion of investigation and that the petitioner is in custody since May, 2022. Paragraph accordingly.
20,000 with 2 registers your like amount. Satisfaction. Which court, sir?
The Lordship.
Learned additional session judge, second court, Siliguri.
Siliguri.
On condition that the present accused petitioner shall not leave the territorial jurisdiction of the learned trial court till conclusion of trial, unless such condition has been relaxed by the learned trial court, with the further condition that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing. No 317.
Item number 28.
Is what?
আমাকে একটু সিডিটা দেবেন।
No,
No, we
second
will
court.
come back.
After 37, we'll make a second.
After 37, we'll take a second. We'll rise for the occasion and we'll come back soon.
Oh.
12.
We'll-
Next item 34 next circuit.
34 next circuit.
34 next circuit.
One matter, Lordship, item number 31, that is come up not today. Lordship, is a cancer patient, so kindly the CD must be there. Tomorrow, kindly.
We have made not today means there is a request to the state to ensure the production of the CD.
31, if they file some documents, just give us the documents, Lordship. We verify those documents, their genuineness.
Why can't you produce the CD tomorrow?
That CD not present, Lordship.
Tomorrow, come back to the CD.
Furnish the documents of your illness.
Are you hearing?
Oh, 41 without. What is there?
এইভাবে আমাদের এইভাবে আমার 16
আর কি হবে একটু আগে আমার বলবো। এটা আমি যেগুলো আছে সেটা কালকেই করবি কালকে পরশু
কিভাবে হবে? তো যাবে ভেরিফাই হবে তারপর তো
রিপোর্ট পাঠিয়ে এরকম শুরু করলি হঠাৎ করে ঠিক আছে অরিজিনাল তো আমরা দেখাবো না তোর তো যায় আসে তুই শুরু করছিস সেটা দেখ তুই আমারটা খাবি আমি তো এখানে তো সিস্টেমই চলছে
What we have made up in their mind. Why we are instigating us to make submissions, you know? What's a ratio banana? Baby is from there. Genuine. পরে আছে আরো বলা একটা বউয়ে 5 দিন 10 দিন একলা হইতে মানে ওটা বসবে মহামূল্যবান যাচ্ছি না অনেক আমরা বিল্ডিং আছে কত নম্বর চলে গেছে ধরতে পারবো কিনা আমি তোমাকে understand our predicament because clarity is scale and activity will have to statement
আমি ছুটি নিব অফিস থেকে বলে ছুটি না ছুটি প্রথম সপ্তাহ হচ্ছে 24 থেকে হরিষ্ঠ তারপরে 2 সপ্তাহ দেবাংশু বসাল হয় না 2 সপ্তাহ করে 3 সপ্তাহ 3 সপ্তাহ খুব 3 সপ্তাহ হ্যাঁ ভুলবো ও হ্যাঁ Matters, item number 127, 128.
And for the petition, my lords. You have completed.
Yes, I have completed.
Yes.
It's for Mr. Ganguly to reply for the state.
Yes.
Copy of the CD or the original?
This is the original CD.
While passing the judgment, we require the photocopies of the.
Lordship can keep the original also.
No, no,
No.
no.
Then I have to obtain the.
Please take the trouble, ask your officers
Xerox CD.
to make a complete set.
Lordship,
You still have time.
Lordship,
We conclude the.
Lordship, Lordship,
But we require
Lordship,
the
Lordship,
photocopy of the entire. CD.
Lordship. Now hearing Lordship 41B, Lordship has already considered two matters. I make my submission to a small point. From the first day what I was submitting, Lordship, that 41B is applicable in cases because it's a statute supported by Appeals Court judgment, D.K. Basu. But once again, Lordship, in spite of Lordship has already considered, my humble submission is that the petitioner has to bring out a case to take the advantage, because as per in NDPS Act, the culpable mind, criminal mind, the burden lies upon the petitioner. If Lordship sees the page 8 of their petition is the affidavit. In affidavit para 2, the statements made in paragraph number 1, 4, and 5 are true to the to my knowledge. So, under the Oaths Act, the affidavit has been sworn, and they are admitting that it's true to their knowledge. Now, if your Lordship sees para 4 of their petition, that is in page 4, the petitioner was arrested on 3/2/22 in connection with the above case, and since then he is in judicial custody. So this fact, the petitioner was arrested in connection with this case and on the date, which appears in the arrest memo also, which has been, as per the petitioner, true to the best of their knowledge. So admitted fact, and this is the affidavit is not mere formality, Lordship. It's in support of the petitioner, the genuineness of the petitioner, and they are asking the court to believe that they were arrested on this very day in connection with this case. Now, Lordship.
Tell us one thing. Can you use this document as an admission within the meaning of the Evidence Act?
Not in that sense, Lordship. I do humbly say, not in that sense, but my point from the inception of my argument was that in a case of NDPS, I started my argument, Lordship may recall, from Geneva Convention 1961, that the logic behind framing this type of Decorian Act, if we say, throughout the world, is to curtail the menace of this drug racket and other, which is spoiling this society.
It'll help you what is passing through our mind. We are not saying that the provisions of the NDPS Act should not be implemented. We fully appreciate. Why can't the police follow the procedure laid down by law?
Lordship.
That's the only thing.
Lordship.
So that we'll have no occasion to dilute 37.
Lordship. My humble submission is that to dilute the 37 regarding the factual aspect, they have to make certain pleadings even or documents before the trial court that to curtail the case of the prosecution. In this regard, Lordship, if there is a different opinion regarding the statutory provision and the gravity of the offense, I play CC Online Supreme Court 785. It was just decided 2-3 days prior to this by the Honorable Apex Court. And we see para 19 of the judgment, Lordship. Though this case was
just a minute
regarding anticipatory bail, Lordship, but একটু পড়িনি para 19 the relief of anticipatory bail
Just a minute.
One second.
Para
19 lordship may I read lordship
1 second, sir. Yes.
though this was an anticipatory bail or is the bail but the ratio which has been laid down, the relief of anticipatory bail is aimed to safeguard the individual rights. And so I say, lordship, the curtailment of statutory provision also harms the individual right. So it has to be safeguarded also. While it serves a crucial tool to prevent the misuse of the power of arrest and protect innocent individuals from harassment, it also prevents challenges in maintaining a delicate balance between the individual rights and the interest of justice. The tight rope we must walk lies in striking a balance between the guarding individual rights and protecting public interest. While the right to liberty and presumption of innocence are vital, this is very important, lordship. While the right to liberty and presumption of innocence are vital, the court must also consider the gravity of the offense, the impact on society, and the need for the fair and free investigation. The court's directions in weighing these interests in the facts and circumstances of each individual case becomes crucial to ensure a just and outcome. Each and independent case, lordship. In our case, as because the only the para 11 remained blank,
Column 10.
column 10 remained blank, they have jumped into the arena stating that I am entitled to the benefit. But it may be a mistake by the authority, police authority at the time of arrest by not taking the signatures of independent witnesses in that sense. I may admit, because I cannot go beyond the periphery of the case diary, which
You cannot develop.
lordship. But this plea that they have been falsely implicated, they should have at least taken before the trial court, at least a piece of paper, at least anything to support their case, so that the onus can change and shift upon the prosecution to prove their case. That's all I say, lordship.
So hearing is. So hearing is concluded. In this matter, this is not her matter.
Lordship, another one matter 435 is analogous with it, Lordship. Lordship, I am mentioning that neither in the seizure list nor in the arrest memo the signature of respectable person of the society or individual.
Madam,
witness
1
is
second,
there.
is that matter in the list?
Yes, lordship.
Lordship,
With this matter.
Lordship.
She was harping on this from the last day also, that her seizure list does not contain the signature of the independent witness.
One of her matters, we have judged.
Yes, and this is another matter.
Another.
Ma'am, in your case, it is your case that in the arrest memo there is no signature of the
Neither in the
witness
arrest memo
or a
nor
relative.
in the seizure list, Lordship. In both the cases, no individual witness signature is there, Lordship.
He filed the law?
One line in reply, my lord.
Just a minute. Ma'am, one thing, please tell us the number of the CRM number which has been.
CRM number, NDPS.
No,
435.
CRM number where hearing has been concluded, judgment has been reserved.
Lordship. In one matter, Lordship, this is another matter, Lordship.
Which is that matter? Give us the number of that matter where judgment has been reserved.
Oh, Lordship, I am giving, Lordship.
If it is right, not right with you, it is lying with my chamber. No issue.
Achha. Now, let us then, before taking up Ms. Dotto's matter, let us get finished because he wants to say something in reply.
One line in reply.
Yes.
My lord, Learned Counsel for the state has said that it might be a mistake on the part of the investigating agency by not getting the signature in column 10. But he very carefully avoided the suspicious circumstances. I pleaded before your lordship that the suspicious circumstances revolving around the entire event, when the signature, the handwriting of the seizure memo does not match with the handwriting of the arrest memo.
You have
As well, my lord.
Don't repeat, sir. You've said, you've made these arguments.
Yes.
In your opening submission.
Yes, madam. There is one section
Lordship, my case, Lordship, that my the case of the prosecution in this type of cases is putting the cart before the horse. What has happened to the-
We have noted your arguments. Hey, dekho. Hearing is concluded, judgment. আর ওই 138 টা ওনার কি বলার আছে বলে এগুলো সব
Same submission.
ঠিক আছে তার ওটা তো হিয়ারিং
Hearing conclude to it.
138 টা আলাদা করে করুন
I'm giving.
Photocopy of the sheet and hand over.
হ্যাঁ 138 Mr. Ganguly, then kindly take the trouble both in 137 and 138.
Lordship, Aniruddha বিশ্বাস is
Please tell him
yes, Lordship.
To give us just give us
Lordship, and in the matter where judgment has been reserved, that CRM number is CRM NDPS 428 of 2023. 428.
Thank you. Thank you.
In today's matter, you have handed over the photocopy of the seizure list.
Lordship, neither in the seizure list nor in the arrest memo, Lordship, the signature of respectable person of the society or individual witnesses there, Lordship.
No, we got the photocopy of the seizure list. What is the photocopy of the arrest memo?
Lordship, that is with Mr. বিশ্বাস, Lordship.
Mr.
In the,
So, which is why we require the
CD,
Lordship, I'm giving the instruction. Okay. Tomorrow we can hand it over this.
শোনো 137 টা যেটা লিখলে তার আগে লেখো
Okay, 127 with
127 sorry 27 and 28
Lordship.
127 এ দেখো hearing is concluded, judgment is reserved. Get it out. Stop. By Friday, when will you give?
Yes, Lordship.
State advocate is requested to file a complete set, photocopy of the complete case diary of this case by tomorrow.
Lordship, it's Kumargram. It may be Kumargram. It's more than
By Friday.
200 kilo by Friday.
By 2 p.m. on Friday date ta dao. Paragraph judgment is reserved. Same act. 128 is same order.
Grateful.
Grateful, Lordship.
127 is.
আমার নোটটা আমি লিখে দিচ্ছি সোমনাথকে একবার ডাকতে হবে তো এই সোমনাথকে ডাকুন
Lordship, in both the matter, judgment has been reserved.
Yes.
Lordship, grateful.
We have reserved practically in 3 matters. Judgment reserved 3 matters. Your 2 matters of yours and 1 matters of yours.
Because of common points involved, we don't want to pronounce individually. Together, we'll consider.
Grateful, Lordship.
We see. Good. So we can continue with the list now.
Item number 35. হ্যাঁ বলার আগে আমি বলে দিই
34টা হয়ে গেছে 34টা হয়ে গেছে
34টা 34টা not today হলো না next 35
the same point 41B
Lordship, kindly page number 14, 15 and 16, Lordship.
ওই same order ই হবে
Lordship,
তাহলে, আবার
হ্যাঁ,
তো আগে বলে
ওই
দিয়েছে।
কোনটা যেন হলো লাস্ট 33 তে যে অর্ডার করেছে 33 it was 33 no the last one
40 ওখানে দেখুন ওই কমপ্লায়েন্স নেই দেখুন ওখানে এর কথা বলা হয়েছে। আরে আমাদের যেটা দিকে বাসুস জাজমেন্ট দেখুন না, দিকে বাসুস জাজমেন্ট বললো
33 IT যেটা উই তো নিলে
Yes, Lordship,
ঠিক আছে।
33.
33
সেম, নো সিগনেচার,
No signature.
ব্ল্যাঙ্ক,
Blank.
কলাম নাম্বার 10 ব্ল্যাঙ্ক,
Column number.
সেম অর্ডার।
এই একটা খালি অ্যাড করে দিও the observations in this order are prima facie for the purpose of disposing of this
Grateful, Lordship. Grateful.
disposing of this bail application.
Grateful, Lordship.
Tentative.
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 36.
I am for NCB.
Oh, 35 to the way.
36 for the petitioner. Next, sir.
37.
37, Lordship.
State.
37 K.
Passover. Call the passport matters then.
হ্যাঁ
Passover master. 8. আগে আছে?
Item number 3.
Okay.
Well, I am for the
Item number 3.
State.
No, 3, I am for the petitioner, Lordship. This is a matter relating to cancellation of bail.
3
Yes, Lordship.
Oh, wrong.
That is wrongly listed
Lordship,
under
I
the heading.
could you for a short passover, Lordship.
no cancellation
তো restrict করে দিন।
Regarding
Please do.
cancellation of.
it will be listed under the proper heading.
All right.
Not today.
One more thing, Lordship, may I be permitted to.
Report number 3.
Is his
Wait.
application, the matter is appealing under a wrong heading.
We have to apply adjourn today. We have to adjourn today.
But Lordship, what I find from the affidavit of service which has been supplied to me by the advocate on record, we have sent the notice that has returned due to insufficient of address. But the address which they have provided, we have served at the address. If the service may be done through the
You are for whom?
state.
Lordship, state.
State, but what about the person who's enjoying bail?
We have served, but due to insufficient address, that has come back.
Is it a POXO case?
No, 498.
So what is the requirement of service to them?
If the bail is cancelled, then they will be affected.
No, that we understood. You know the address of your adversary. You are the wife, I believe.
Yes, I have served at that address, but that has come back.
No. You are the wife.
Yes, Lordship.
You know the address of your matrimonial home. You have served. If service is complete, what is the requirement?
Due to insufficient address, that has come back. So if the service may be.
Next circuit, you do whatever you can do.
If direction may be given through the, again, we will serve, again that will come back. If we may be directed to serve upon through the.
It is
officer in
reported.
charge.
Is item number 3, no? It is reported that
498
the
is
instant
307.
matter being an application for cancellation of bail has been placed under wrong heading. It is also reported the service upon the private opposite parties could not be effected due to the postal remarks insufficient address. Yes. Learned advocate for the petitioner, the submit before this court that an order may be passed for effective service upon the private opposite parties through the state agencies.
Yes.
Stop. Prayer for service upon the private opposite parties through which police station?
My lord. Siliguri Women PS.
Through Siliguri Women PS. is hereby allowed. Petitioner is hereby directed to hand over sufficient copies of the application for bail to the learned advocate for the state for onward transmission of the same through the concerned PS to the private opposite parties. Let the matter be listed before the next circuit under the heading cancellation of bail.
Item number 4.
What is the nature of offence, sir?
Allegation under section 302 of the Indian Penal Code, my lord.
What is the stage?
Charge sheet submitted, charge not framed, my lord. Custody about 260 days, my lord. Can you see, my lord, allegation that
Is a case based on circumstantial evidence or a ocular witness?
circumstances and said that I called him and hit by auto car. Both are relative. There is a previous quarrel. Kindly see the serological report and chemical report, my lord. This is not substantiate the story that by the car he was hit, my lord. Kindly see the injury report, my lord. There was a previous quarrel. I called and he came from the house. Thereafter, I hit him.
My lord, that is the statement of the 164, my lord, eyewitness, and he was present during the spot. My lord, he was also injured because of that car. Injury report is there. So, my lord, it seems that from the, my lord, the accused petitioner was running, my lord, and my lord, he hit the accused. He hit the victim with the running car.
Why 302?
302, my lord, because there was an attempt, there was an intention, my lord, from the 164. Because there was a hot altercation. After that, he banged the door, my lord. Then he started his vehicle and ran over this victim, my lord. My lord, what was the cause, my lord? De facto complainant is the wife of the victim, my lord, and Govindo Burman had married his sister-in-law. His
So
sister, my lord.
the deceased was run over.
He was hit. The deceased was hit by the vehicle, my lord. Then he fled away from the spot, my lord.
আমাদের জামাই উত্তেজিত হইয়া পড়ে এবং আমার স্বামীকে ধাক্কা দিয়ে মাটিতে ফেলে দেয়। আমার জামাই দ্রুত অল্টো গাড়ি নিয়ে চলে যায়। What does it mean?
That means, my lord, he was called in the spot, my lord. He was called in the spot. Then there was a hot altercation between this victim and the accused, my lord. Then, my lord, by alto, my lord, he ran over this accused by this victim. He ran over the victim, my lord. That is the 164, my lord. This victim also got injured during that quarrel.
Can you see the
So
medical?
the person who died, he was taken to hospital
He was taken to hospital.
and died there in the hospital.
Yes, my lord. Injury, my lord, because of the head injury, which he suffered.
Can you see the medical report and serological report, my lord?
No. কোথায় আমি সেটাই বলছি বুঝলি না ওর হাতে লাগে ওর যায় আমার দাদাকে সামনাসামনি ধাক্কা দেয় দাদা অনেকটা ছুটতে হয়ে গোবিন্দ গাড়ি নিয়ে পালিয়ে যায় It was not in hit and run.
It was purpose, my lord, on purpose.
আমার দাদাকে সামনাসামনি ধাক্কা মারে দাদা অনেকটা দূরে ছিটকে যায় গোবিন্দ গাড়ি নিয়ে পালিয়ে যায় What is the PM report?
PM report is at page number 41.
It was not an hit by car. Let's see. This one is the solution of this গাড়ি রান ওভার হয় আমি তো হাত পা ভাঙবে এখানে তো শুধু অ্যাপ্রেশন দেখা যাচ্ছে অ্যাপ্রেশন এখানে মাথায় গেছে Does it come under 302? He was not hit by the car. What report you intend to show?
A serological report, my lord.
That is there.
There is no serological report.
Charge is submitted.
Yes, my lord.
Charge is submitted 17/12/20.
আসুন ভাই Third, learned advocate for the petitioner. And learned advocate for the state at length. It is contended on behalf of the petitioner that considering the fact that the alleged incident might have occurred on account of family dispute and hot altercation, and considering the fact that investigation has already been completed in the meantime, the instant application for bail may be considered favorable. Prayer for bail is opposed on behalf of the state. Stop. We have perused the entire materials of the case diary. Stop. Prima facie, it appears that the alleged incident occurred on account of family turmoil over which the present accused petitioner have given a heavy push to the victim, as a result of which he suffered injury on his head and subsequently succumbed to such injuries.
Which he fell down and suffered.
Stop there. Investigation has been completed. Investigation is stated to have been completed in the meantime. Stop. In our considered view, this is not a fit case for custodial trial. Accordingly, we are inclined to exercise our discretion in favor of the present accused petitioner. It is as ordered that the present accused petitioner may find bail rupees 10,000 with 2 ratios like amount. Satisfaction.
Additional subjudicial.
No, additional session judge FTC Siliguri. It has been committed, no.
Bond may be submitted to CBI.
Satisfaction, bond there is no issue. Additional session judge fast track court Siliguri. With a further condition, ওই রোজই অ্যাপিয়ার করবে সাবজেক্ট টু কন্ডিশন অফ সেকশন 3 মনে আছে তো শুধু 3 খেয়াল করে আর কিছু দরকার নেই
Item number 7. Yes, madam. Previous rejection, madam. Annexure C1.
6 March 2020. Annexure
C1, madam. Page 11.
So you are the principal accused.
Madam.
As per finding of the
As
coordinate.
per finding, madam. If you should kindly see the first information report. FIR was registered again unknown misprint, madam.
No,
madam.
We cannot take any contrary stand to the.
Madam, contrary stand, madam. First FIR was registered unknown miscreant, madam. Thereafter, investigation transferred to the CBI, my lord. And when the 164 of the witness was recorded, my lord. And the first instance, there is saying that there is no one. And there are several co-accused persons granted bail by this Honorable High Court. And I am in custody about 2 years. There is list of witness more than 60.
What is the stage?
Till today charge not framed, my lord.
Lordship, last occasion, this honorable
Mr. Majumdar, is there any eyewitness that he fired at the
Yes,
victim?
yes, Lord.
Eyewitness?
Yes, my lord.
Named him?
Yes, my lord. He arms has been recovered from him. And my lord, if your lordship, may I be.
There's a
permitted to-
recovery statement also.
Yes, my lord. My lord, on last occasion, this honorable court was pleased enough to reject bail application of a co-accused and has fixed 27 July to charge to be framed. May I, but he is the principal key player in the whole incident, my lord.
Political. Case of investigation and transfer is a political right with possibility of false implication cannot be ruled out, my lord.
That is a matter of trial.
That can be.
More than 2 year custody, my lord.
How many charge sheeted witnesses are there?
60, 67.
How many charge sheeted witnesses are there?
60 lordship.
60. In a murder trial, 60.
Yes, my lord.
Lordship, it is not a murder trial, it is a mayhem was.
3 and 4 substantive.
Unruly,
explosive activity.
unlawful assembly, rampage. This.
Which is why
victim-
147,
My
149.
lord, this victim was only 1 of age. He was married in that year. He went suing for peace, that let us live together. We are villagers, co-villagers of the same village, and he was shot on the spot.
It's too early.
We are
No. After the rejection, March this year rejection. Not inclined. What do you want to do? Not pressed.
My lord, we suffer, my lord.
What?
Why?
No, then we can say after.
My lord, we suffer in two ways. One, I cannot bring out before my lord. My lord,
1 p.m.
my lord,
No. Not fair.
my lord, only one line may be recorded. CD was produced, my lord.
Chalo. The state has produced the case diary. Stop. However, learned advocate, it says has instructions not to press.
Item number 8.
Please, your lordship. Lordship, this incident occurred in the year 2017.
How is the weather of Darjeeling now? Tell us.
It's raining, lordship. And charge sheet was filed in the year 2019, lordship, 4/9/2019. There are 27 accused, lordship. I have given some
Lord,
details
report.
of this.
There was a report was called for.
Yes, still not there.
Through
No,
report has come.
In the last occasion, it
has
was
come.
directed the state to produce the report,
Report
lordship.
has come. It is on record, my lord, before your lordships.
It is come. He coming here, isn't it? Huh? No. Yeah, that one.
Judgment.
My lord, may peruse last page 11 and page 12 of the report, my lord.
Page 11 and page 12 or 3.
That will be part of the prosecution, my lord. Last paragraph of the running page 12, my lord.
Commencement ঠিক আছে তো? Commencement ঠিক আছে তো?
এইখানে বলছি
Other actors may be
স্ট্যাটাস রিপোর্ট কল করে রিপোর্ট করলে এত directly process letter এ আছে when only immediate affairs in national department and the reason for not being able to obtain jobs till date এবারে সেখানে এখানে বলছে investigation is mostly open. Against a number of officers. So the intent was used to mean such a group of political candidates. So I was saying about the which has been found in this case, was the very present on the part of the prosecution. When on the part of the prosecution or charges, it could be reason for not being able to credit.
My custody for
CS is far too long at that.
Yes,
Maybe
Lordship.
there's no latches on your
Lordship,
part.
at
maybe.
any stringent condition, Lordship.
Stringent conditions.
Yes, Lordship.
Guarantee it has not even been committed.
Yes, Lordship.
My lord,
Lordship,
My lord.
6 years.
During the time.
Agitation.
My lord.
Hey,
What's
Isho.
the
Isho.
scenario, my lord?
my lord, these people, my lord, they have direct, my lord, incriminating materials in the city.
Lordship,
this
I
case
have this
that is-
paper, one Firoj.
Lord, the case diary says,
Let us.
my lord, one submission.
You are who?
My
You
lord,
are
I'm
the
from state, yes. My lord, the case diary says, my lord, that there is leading to recovery from these people, my lord, huge amount of arms and ammunition, explosives, and one police
They
official.
convict them without holding a trial.
No, my lord, I'm not saying that. I'm not saying that. But my lord, one police officer has died, my lord, in this case. my lord, from the gunshot injury, my lord. My lord, let the trial be splitted, 309 be invoked, let there be day-to-day trial, my
No,
lord.
sir, 6 years.
My lord, day-to-day
Too
trial,
long
my
a
lord.
time, Too
My
long.
lord,
a time.
your lordships may direct, my lord, that day-to-day trial.
Why don't you agitate that matter before the
Yes,
Learned
Lordship.
CJM Darjeeling? Why there is no
My
no
lord, there is-
application on your part?
My lord, the report is
Lordship,
before
we
your
are
lordship, my
voting
lord.
no
We have
vote.
done our best, my lord. There is no latches on our part, my lord. The report is before your
It
lordship.
is true that the charges
But
are,
fact remains that the matter has been
grave,
pending for a considerable length of time.
comma, under various sections of the IPC, including section 302, stop. However, comma, the petitioners, one or more petitioner,
There are 9
nine petitioners are in custody for more than 6 years. Stop. The আচ্ছা আগে একদম গোড়াতে বলো, report as was called for by this court has been filed
Learned CJM Darjeeling.
by the learned CJM, that comma Darjeeling, stop. We have perused the report, stop. It inter alia comma states that there is no latches on the part of the state in proceeding with the matter. Paragraph. তারপরে যেটা বলেছিলাম, more than 6 years, stop. The case has not yet been committed. Since it appears,
Since execution oblique returns of the warrants of arrest.
since execution,
Since the execution / returns of warrants of arrest and WPA of several accused persons are still pending.
that's pending, stop. Stop,
As reveals from the report of the CJM.
comma, as appears from the aforesaid report of the CJM, stop. Naturally, comma, charges have not been framed.
Naturally, commitment could not be done.
Commitment having no charge.
Naturally, commitment could not be done. That is not asking it.
না আমি বলছি কমিটমেন্ট হয়নি এই কারণে, সেই জন্য চার্জের প্রশ্ন শুরু করেছিলাম কিভাবে আগে সেন্টেন্সটা, কেস হ্যাজ নট ইভেন বিন কমিটেড।
Case has not yet been committed.
Stop. না কেটে দাও। Paragraph. We cannot be unmindful. Now, although there may be no latches on the part of the state, comma, we cannot be unmindful of the importance of Article 21 of the Constitution of India and the principles of law laid down by the Honorable Supreme Court in the cases of Kashmira Singh, etc. Stop. Paragraph. There is no certainty as to when the trial shall commence or conclude, or stop. In view of the aforesaid decisions of the Honorable Apex Court, comma, we are inclined to enlarge the petitioners on bail, but on stringent conditions.
My lord, what is, trial may be splitting, my lord.
Even then,
May find bail out with 5,000 with 2 registers to 2,500 each.
Grateful, Lordship.
Satisfaction learned CJM Darjeeling with the further condition that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing subject to the provision of section 317 CRPC with the further condition that the present accused petitioner shall not leave the district Darjeeling unless permitted by the learned trial court. Stop. Considering the delay, as occurred in Darjeeling Sodor PS case number 213 of 2017, 213 of 2017, learned Chief Judicial Magistrate Darjeeling is hereby directed to take appropriate steps for splitting up the trial and for immediate commitment of this said case to the learned session judge after complying all legal formalities.
Grateful, Lordship.
May I take the lordship's regard to item number 122, it's a bail application. Anticipatory bail application, 122.
What do you want?
The DPT has been taken up anytime before your lordship.
Jump the queue? Why?
That is the reason that I was asking for the indulgence.
We must be equal, we must be equal to everyone.
No, I'll wait.
Yes, hello there. Yes.
Why not, may I be permitted to make mention two matters that are much predicament and coming before my lordship? My lord, actually, I have mentioned two matters, one in the last week and one today, portion number 2. But my lord, my mentioning has been refused. My lord, I am in a very precarious situation here. One of the petitioner is a cancer patient, and because of which, my lord, I was.
What matter? Writ matter. Writ matter, I don't have the determination. I'm not it.
My lord, it says if any other matter as my lord pleases, hence I'm mentioning.
No, but what is it?
My lord, group 4 matter.
Where is the matter? If I don't know whether I'll be able to sit singly again, there are 2 days left. Please appreciate, madam. I don't know. Give the slip. Look, আমি যদি বসি তাহলে দিয়ে দিও.
Item number 1.
Lord, may it please your lordship, Lord, I appear for the petitioner. But am I audible to your lordship, Lord?
Yes.
But I'm sorry, Lord, I could not go there personally. But I tell you, lordship, Lord, kindly, Lord, state may come to, Lord, the arbitration clause. Kindly take page 96.
Who is for
Page
the other
90.
side?
My
You are appearing.
lord, I am appearing for 1, 2, 3, my lord.
Lord, we have served on everyone.
And the government of India?
Lord, we have served on everyone, Lord, the affidavit of
Where is the
service.
affidavit of service? Yes. Served.
Lord, kindly take page 96.
96, yes.
Yes, kindly look at the clause, Lord. Clause number 3 by 25.38. Lord, I'm reading it for your lordships. I'm sorry, Lord. I'm
So
sorry.
this is
I'm
a
sorry.
contract between whom? Between you and who?
Lord, this is a contract. Lord, this was a project of government of India, but Lord, the project is being run by the state government. It's a highway project, construction of Lord, highway roads and Lord in Paglajhoda and Lord blockage on the hillside.
So
That's the
therefore, this agreement is signed on behalf of the state or the union?
Yes, is signed on behalf of the state. I have annexed the agreement also, your lordship. It's there. This is only a part of the agreement. My lord may see who has signed it at the bottom of the page. R.K. Sharma, Superintending Engineer, PWD Roads, Directorate, National Highway Circle, Siliguri. Is a party at the bottom of the page. Now kindly take 25.3. In case of dispute or differences arising between the employer and the domestic contractor relating to any matter arising out of the or connected with this agreement, such disputes or differences shall be settled in accordance with the Arbitration and Conciliation Act. The parties shall make effort to agree on a sole arbitrator, and only if such an attempt does not succeed, and the arbitral tribunal consisting of 3 arbitrators, one of each to be appointed by the employer and the contractor, and the third arbitrator to be chosen by the 2 arbitrators so appointed by the parties to act as presiding arbitrators shall be considered. Now, what has been done here is that my contract has been terminated by them. Thereafter, without giving me a hearing, I challenged that order before the Honorable Single Judge by filing a writ petition. Lord, the matter went up to the division bench. The division bench protected my right and relegated me to arbitration. I went and filed a Section 9 application. I am protected till 29th of July. I issued Section 21 notice. Your Lordship will get that invocation letter, Lord, at page 273. Kindly have a look at page 273.
Sorry, can you please repeat? You come again, Mr. Chakraborty?
Lord, I have invoked arbitration.
Yes.
The 21 notices at page 273. I have nominated Lord Honorable Justice Jyotirmoy Bhattacharya, Lord, retired Chief Justice of Calcutta High Court, and requested them to agree on that. Kindly Lord come to page Lord 289, the last paragraph. I have given the entire dispute. They have terminated my contract. I challenged that initially in a writ petition. Then that went up to appeal. Division bench of the Honorable Chief Justice protected my right, relegated me to arbitration. I filed Section 9. I am enjoying an order of injunction. I invoked arbitration. I said that you give consent to justice.
Yes, I followed. Now, what happened after this letter?
Take the next page. Take the next page. Next page. This is the response. Please refer to the letter under reference. Malakari, take the third paragraph. Now, as per the provisions of the contract agreement, clause 325.3, which I have shown at page 96 of the ACC of the contract, this is to inform you as per approval of Ministry of Road, Transport and Health, Sri Ashok Vasan, member technical retired NHEI, so and so, has been nominated as arbitrator on behalf of this end and the employer in the aforesaid arbitration. Now, as desired by Ashok Vasan, arbitrator on behalf of the employer is. But I say that this is hit by Note 12.5. Is an ex-employee of NHEI against whom the arbitration is going to be happen.
Sorry, I can't hear you properly. It's
Not
not
this,
clear.
this gentleman who has been nominated by the respondents in page 290, he is an ex-employee. So this is hit by Note 12.125, section 12, subsection 5 of the Act, as well as Parkin's judgment and the latest judgment of the Supreme Court.
He is the what? He is?
But kindly say he is the retired member technical retired NHEI. Ashok Vasan, member technical retired NHEI.
Yes.
He is a retired employee. But kindly take section 12.5 and the 7th schedule.
Without.
Kindly take 12.5. Notwithstanding any agreement to the contrary, any person whose relationship with the parties or the counsel of the subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as an arbitrator. Kindly have a look at 7th schedule. But in my book, it is at page 67. I don't know your lordship's book, not page. And first column, 1. Arbiter is an employee, consultant, advisor, or has any other past or present business relationship with a party. So he is absolutely ineligible to be appointed as an arbitrator. Well, you see, NHEI, retired technical NHEI.
Yes, NHEI, your arbitration will be with the state.
No. NHEI is the authority. State Milord is performing the contract. Lord, it is a project of National Highway. It is a, kindly take the contract now. I'll show you. It is a project of National Highway.
You will file your statement of claim against whom?
Lord, against the NHEI as well as PWD Roads NHEI.
Against both.
Yes. They are kindly take the contract once, page
Yes,
36.
Mr. Chaudhary, what do you say? Change the personnel? Because it appears to be hit by clause 1 of 7th schedule.
Lord, shall I cut short the matter?
Yes.
My proposal would be,
Yeah.
let the petitioner suggest 3 names.
Yes.
We will also suggest the 3 names. then I leave it to your lordship's decision.
Very good suggestion, Mr.
Lord, may I just say one thing, Lord, I completely agree with him. The clause says that one arbitrator can also be appointed. So it will save cost of both the parties. Any of the retired honorable judges on whom Mr.
That I'm
Chaudhary
saying,
will not,
that I'm saying, we'll
Yes.
refer 3 names.
Lord, I will not name any, I will not.
They
give any
have
name.
already suggested one name, that is retired Chief Justice Jyotirmoy Bhattacharya. Now you may take instruction on this and we can come back day after tomorrow for
That's why
final.
I'm saying, my lord, we will refer the 3 names, my lord. Out of that, one arbitrator can be appointed.
So you suggest 3 names apart from
Lord,
Justice Bhattacharya.
2 names.
Lord-
Apart from Justice Bhattacharya, 2 names.
Lord, my elder brother,
Out
Mr.
of them,
Georgie,
one may be appointed.
Yes, out
So,
of the 1 may be appointed.
out of them, a sole arbitrator may be appointed.
Lord, my elder brother, Mr. Georgie Chaudhary suggests the names, I agree. I don't have any problem.
Suggest the name.
Lord, Lord, whatever he says,
Are
I
finish
just,
it off. Suggest a name. You
Yes,
want to come
according-
back
Tomorrow then.
Tomorrow.
Georgita,
tomorrow
right
at
now.
tomorrow at
I'll suggest the name.
tomorrow at 1:10. You'll get 5
Matter
minutes.
of 2
more.
minutes. Lord.
Tomorrow at
But
1:10.
Lord, I want a judicial order from your lordships on one issue, Lord. And Lord, Mr.
Definitely a
Chaudhary,
judicial order will be passed.
Mr. Chaudhary is there at, Lord, appearing as the additional advocate general without not treating us. But I did not recognize him. But you cannot,
Don't
you
waste
cannot
more
Lord,
court's time.
recognize.
We are going to
cannot
treat you on
recognize.
Friday.
Issue.
Receive the hospitality.
You cannot recognize him.
This application has been taken out for appointment of a fit and proper person as an arbitrator to adjudicate the disputes that the petitioner claims, has arisen, have arisen, petitioners claim have arisen between the parties. Paragraph. It appears that the NHAI designed a project which is being implemented by the state government.
State PWD.
State
PWD.
State PWD. Stop. Part of the work was awarded to the petitioners. Stop. An agreement was executed by and between the parties, which contains an arbitration clause for resolution of possible disputes and differences between the parties. Stop. Paragraph. The petitioners say that disputes have arisen in connection with such agreement, and therefore the same need to be resolved by way of arbitration. Stop. The petitioners had suggested the name of a learned former Chief Justice of the Calcutta High Court as the arbitrator. Stop. The respondents have suggested the name of a gentleman who, according to the petitioners, cannot act as an arbitrator in view of the bar in clause 1 of Schedule 7 to the Arbitration Act, read with section 12 bracket 5 of the said act. Paragraph. To cut the matter short, the Mr. Chakraborty, learned advocate representing the petitioners, has suggested that Mr. Chaudhary, learned additional advocate general representing the state respondents, may suggest 3 names who can act as the sole arbitrator. Stop.
Out of the 3 names.
Huh?
Out of the 3 names.
3 names, out of whom one may act as the sole arbitrator. Stop. Mr. Chaudhary says that he will come back with instructions tomorrow. Date ta diye dao. Paragraph. Let this matter be listed once again. Kalke date marked 1:10 p.m.
Preferably a retired honorable High Court judge, because the claim would be in few courts.
Shall I say that?
I will come up with 3 names.
3 retired High Court judges.
That would be not
Very well.
right now. Don't indicate lordship. We will come up with it.
Maybe a senior
Maybe
senior counsel.
Yes.
Yeah.
Or maybe
But not
the the judge of the Supreme Court, my lord.
Yes, 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 yes,
Not
yes.
only the High Court.
Not
Yes,
only
the
retired
checking,
High Court or
checking.
Supreme Court judge. I'm grateful to you.
What is this?
The second round of litigation in the past week on Amira was appointed. But the railway authority did not accept it. Then I'll kindly come to case 35 if it's not in the matter.
Who is appealing for the respondents?
Lordship, I am appearing for the respondent, learned DSGI on his legs into court number 2. Your
Union of India.
Lordship, NF Railway.
Yes,
My lord, what is this?
35.
30. The last order.
Order dated 11th.
Yes.
My lord, the last paragraph of the page 35, as the parties consent to refer the issue to arbitration. Order dated 11th May 2023. Passed by Justice Hon'ble.
I direct the.
Yes.
6 line.
You have, yes. Tell us.
The parties further consented that Mr. Vikramaditya Ghosh, chartered advocate practicing in the circuit bench at Jalpaiguri, be appointed as the arbitrator.
Yes.
But thereafter, I have communicated the order, but after lapses of 30 days, they do not act on it.
Yes, what is your instruction?
Lordship, my instruction, the petition filed by the petitioner is kept pending, your lordships,
After 30 days, then
till today, your lordship.
Which petition?
For appointment of arbitration, as there is a clause for arbitration appointed the retired employee of the railway, your lordships. So that the petition is pending, your lordships.
Well, they have consented for this honorable
So,
court to appoint.
consent order is there, sir?
Lordship, it's our lordship, pass necessary order, your lordships. Petition is pending, your lordships. So,
Which petition? This petition is disposed of on which this order was passed.
this petition is disposed of, your
Yes.
lordships. In that time, your lordship, this is a dispute between the contract. This is a licensee porter. She is a defaulter to licensee to the.
My lord, order has communicated by,
Lordship.
passed by this honorable court. I have communicated the order. There is no scope of consideration. They have to do it. My lord, kindly.
One second.
They consented the name of the arbitrator. On the order dated the 2nd May, the Honorable Justice Mukhopadhyay has been directed them to take instruction. After instruction, they came on 11th and consented.
Oh. In the event of failure on their part to respond, then section 11.
Lordship.
My humble prayer is to regularize the appointment of that.
Lordship.
As they already consented, page 44, my lord, kindly see, they have.
Do you agree that there are disputes have arisen between the parties?
Lordship, there is some.
Then the disputes have to be resolved
Lordship,
through arbitration
Lordship,
because there is an arbitration clause. For that, you need an arbitrator.
Lordship,
Now, whom would you like to act as an arbitrator?
Lordship.
Whom? Any particular person of your choice?
No, Lordship. On
This
that-
gentleman,
Lordship,
Mr. Ghosh,
Lordship,
Vikramaditya Ghosh?
Lordship.
अरे अब टिफिन कैसे देवे ना इसको? This is an application under section 11 of the Arbitration and Conciliation Act, 1996. Stop. Paragraph. The petitioner appears to have, where's the clause, arbitration clause?
Page 33, my lord.
33. Appears to have done some work for the Union of India. Whatever work, that's not important. Some work for the Union of India. Stop the agreement under which the petitioner executed such work contained an arbitration clause for resolution of disputes and differences between the parties. Stop. Paragraph. The petitioner says that he has successfully completed the work? No, not yet. Petitioner says that disputes and differences have arisen in connection with the said agreement, which requires to be resolved. Stop. Paragraph. The petitioner had earlier approached this court in its writ jurisdiction by filing WPA 586 of 2023. What was your grievance in the writ?
Terminated at that point of time.
Let's say one.
Directed to deposit my fees and regularize my appointment.
Challenging an order of the Union of India terminating the appointment of the petitioner as contractor. Stop. In that writ petition, an order dated May 11, 2023 was passed.
Giving me interim release.
No. Final release. Point that for
11th May? No.
This 34 annexed C, my lord. I have prior to that order.
No, which order you showed me, Justice Arindam Mukherjee?
My lord, I see order dated page 38, order dated 2nd May.
Page?
Page 38.
Page 43, your lordships. Page 43, third paragraph, your lordship. The petitioner shall continue to pay rent and other charges as per the contract if it is ultimately found that the area of the said lounge is not 1032.69 square feet, but 70969 square feet. As
May 11 বলেছি না? May 11. Stop.
In that petition, order dated such and such was passed.
May 11 was passed. The relevant portion whereof reads as follows. Page 35 থেকে set out করো 35, 36.
Lot.
35, 36, set out 37.
Lordship, may I want indulgence, your lordship. Page 43, para 3 is the main dispute which is.
I'm not concerned, sir, with the dispute. I'm not concerned with the merits. Yes, arbitration.
On that point, arbitration will be.
Whatever the dispute is, I'm not concerned. Paragraph. The petitioner says that in spite of writing a letter referring to the aforesaid order, proposing reference of disputes to the arbitration of Mr. Vikramaditya Ghosh, advocate, the respondents have not responded thereto. Stop. Accordingly, in terms of the liberty granted by the aforesaid order, the present application under section 11 of the 1996 Act has been filed. Paragraph. I have heard learned counsel for the parties. Stop. Learned counsel for the respondents says that the respondents should have no objection if Mr. Vikramaditya Ghosh, advocate, is appointed as the sole arbitrator to adjudicate the disputes that have arisen between the parties. Paragraph. Accordingly, I appoint Mr. Vikramaditya Ghosh, learned advocate, practicing in the circuit bench at Jalpaiguri, in the circuit bench of the High Court at Jalpaiguri, to adjudicate upon the disputes by and between the parties. Stop. The petitioner shall file his statement of claim before the arbitrator Within 4 weeks from date? Stop.
Lordship, one indulgence, your Lordship. What is the dispute is already decided in the writ petitions order, your Lordships. Now, your Lordship, my humble submission, your Lordships, the dispute is already settled, so they did not file again the claim petitions, your Lordships.
You did not file a claim petition. Statement of claim has to be filed.
Lordship, but your Lordship, as per page 43, third paragraph, your Lordship. বাবা, আপনি আরো অনেকগুলো ক্লেম দিলে তাহলে আমার নো অবজেকশন দেওয়া যাবে না, বুঝুন না?
No, no. 4 weeks from date, stop. Counter statement be filed by the respondents within 4 weeks thereafter. Stop. The provisions of the Arbitration and Conciliation Act, 1996 will govern the arbitration proceedings. Stop. The arbitrator fees, he'll this as per schedule. Then we need not mention anything. The will govern, that is all. The act will govern the proceedings. Nothing more.
First sitting, the arbitrator shall decide the venue and the fee remuneration.
Very well. The arbitrator shall decide the venue, the remuneration, etc., and shall proceed.
Declaration.
Eh?
And declaration that he is not.
Oh, and the requisite statutory declaration, and shall proceed to complete the proceedings in accordance with law.
Lordship.
To deposit the fees in the meantime, as per the demand of the railway.
কিসের fees?
What fees?
License fees.
That the order is there already. That order is there.
You had already covered.
By the latest order.
No. If the petitioner has been permitted to deposit the license fees with the railway authorities by any earlier order of this court,
Lordship.
the same shall remain operative.
Lordship.
Petition disposed of.
Order cover করাই আছে।
এটা কে নিয়েছিল? কোনটা ওইটা? একবার এসো না, আমি এখান থেকে উঠি, চেম্বারে নিয়ে যাও চেম্বারে। Thank you. What is that?
Number items.
আর আছে না, তো নেই। That is all.
There's one more matter in your lordship list.
Single list. Oh, yes.
Should I travel the lordship today or will I?
You shouldn't. You shouldn't. Please don't. What is this matter?
Very short.
এই tomorrow কালকের দিন তুমি তাহলে যেটা 1:10 বলেছিলাম, ওটা 1:10 না করে 1 করে দাও। Tomorrow at 1 o'clock come back.
Yes. Readings are complete. I'm very short point.
No, only thing, this is Teraiti, meaning that Ajit Agarwal. Released. No, personal ground released.
That's what I was supposed to tell you. You will see the trouble there.
Nah. I did a lot of cases for him when I was there.
I was not aware of the first day.
Thank you.
My lord, with my lord's kind leave, my lord, before my lord calls on the matter, my lord, the first judgment my lord had given to the item number 1. My lord, the order was uploaded my lord, during the recess. My lord, I have gone through the order. My lord, there is my lord, one very short typographical error. My lord, the partnership deed is dated 12th of December 2005. My lord, by mistake in one place, it has gone down as 12th of December 2001. My lord, it has to be corrected. Instead of 1, it will be 5. That's the that's at I mentioned
To be mentioned tomorrow.
my lord, obliged.
Hey, এখানে section 11 arbitration act with the same CEO হিসেবে মাউন্ট হয় হ্যাঁ কোথায় তো CEO মানে সিভিল বলি বুঝি না ঠিক আছে
I'm appearing for this table.
302, 323, 307, 34 of the Indian. I am in custody for 6 years and 6 months. Co-accused standing on the same footing has been granted enlarged on bail by the Honorable High Court.
Same footing?
Same footing.
The petitioner says that he is in custody for.
That petitioner was in granted bail. He was in custody for 7 years. This petitioner is 6 years.
6 years and 6 months.
6 years.
Stop. A co-accused standing on the same footing has been granted bail by this court. Stop. Paragraph, we have considered the facts and circumstances of the case and the material in the case diary, which is produced by a learned advocate for the state. Stop. It appears to us that the petitioner is similarly circumstanced as the co-accused who was granted bail by the order dated.
Order dated, my lord.
Page 10.
Annexed with the petition, my lord.
Yes, sir.
Page 10.
Dated May 10, 2023 in CRM bracket DB bracket close 171 of 2023. Stop. Paragraph, accordingly, on the ground of parity, we allow this application. Paragraph.
এটা সেট আউট কন্ডিশনটা এখানে দিয়ে দি সেট আউট এইটা আলাদা নাম্বার হয় ডিসপোজ অফ দেখেন
Hey.
Item 29. Column number 10 of the arrest memo.
মানে বন্ধ করে দিই না না এটা এখন ঠান্ডা লাগছে তুলে দিলেই ভালো অ্যারেস্ট মেমো অ্যানেক্সড একদম ডাইরেক্ট গায়ে আসছে
হ্যাঁ একদম ডাইরেক্ট গায়ে
একটু বন্ধই রাখো না পড়া
বন্ধ করে দাও যদি তুলতে না পারে বন্ধ করে দাও ওই তিনটে চলছে তো
অ্যারেস্ট মেমো
Yes.
হ্যাঁ দিয়েছি page
18,
12
my lord, of the case diary.
page 12 he is annexed
ওই সেম অ্যাজ
same as 33 এই তন্ময় 33 না না yes
33
same as 33 এই নম্বর গুলো দেখে নিও আর চার্জটা দেখে নিও ডিফারেন্ট ছিল বোধহয় ওখানে চার্জ
কমার্শিয়াল কোয়ান্টিটি
My lord.
ওটাও তাই ছিল কমার্শিয়াল
ছিল
ঠিকই আছে
Item number 32. Not able to appear on behalf of the petition.
State.
In the third application for bail. But there was a previous direction for expediting the trial. Not the charges were framed on the 6th of January 2023. And 7 months have elapsed, no witness has been examined. My lord, the FIR was drawn on the 25th of January 2021. My lord, the statutory period was to elapse on 24th of July 2021. My lord, the prosecution filed a petition for extension solely on grounds of unavailability of FSL report, my lord. But this is the copy of the petition.
এপ্রিল মাসে রিজেক্ট হয়েছে।
February, April,
My lord, your lordship were pleased to pass an order on 5th of July 2023. Lord.
What is the recovery?
My lord, the recovery in this case is 36.305 kgs of ganja.
What is this judgment?
My lord, your lordship were pleased to pass an order observing the observations in the Subhash Yadav case that extension sought solely on grounds of unavailability of CFSL is not to be accepted.
And the thing in this
Three judge bench.
regarding this point, my lord, they have already argued, my lord. That is how, my lord, two rejections were there.
We
On
find two rejections
February
are there already.
and fourth. This
Two
point, my lord.
recent rejections.
Not
I
inclined.
don't find any.
You have a choice.
My lords, if I may permit, my lords, on the same ground, my lords have already granted bail, even in having rejection in the last bench. My lords, kindly consider the Subhash Yadav, the ratio laid down by the Subhash Yadav squarely applies in this case.
My lord, there are other grounds. My lord. There are other grounds, if I may be permitted.
The earlier benches, my lords, did not comprise any of my lords sitting in this bench.
My lord, 2 years, 7 months I've been incarcerated, my lord. Not even a single witness has been examined. My lord,
My lord, two rejections are there back to back, my lord, regarding the same.
Lord,
ground.
there are
I don't
other
know why they did not agitate this point that time, my lord.
my lord, there are other grounds, my lord.
There is change of circumstance.
Show this judgment to the next circuit bench.
Next circuit would have-
It will be better.
My lord.
It's too early.
My lord,
Ah,
not today.
ah.
my lord.
Not today now, not in this circuit.
Not in.
Next circuit.
My senior would be appearing, my lord. My senior would be appearing, not today. my lord.
Who?
My senior would be appearing.
My lord,
Senior.
Will be appearing. What difference will that make, sir?
Next circuit.
No, reactions are very, very correct. Next circuit, next circuit.
Next circuit, that's better for you.
I'm grateful.
Good.
From me.
Who is for the state?
37.
Then not today. Next.
38.
Not today, lordship.
Not today.
38 not today.
No, 37.
38 then pass over. 38.
My lord, can it be fixed tomorrow, my lord?
Tomorrow.
Not today.
Can it be tomorrow, my lord? I need to take,
Not today, not.
Yes, ma'am. 39. My lord, for item number 39, kindly make it next circuit, my lord.
Next circuit.
Item 40.
I'm for the.
But I am for the petition. But offense under section 498 307 of the Indian Penal Code. Petitioner is the husband and petitioner number 2 is the aunt-in-law, my lord. Marriage took place 8 years ago. My lord, there is an allegation, my lord, that this victim lady, my lord, was subjected to mental and physical torture and was forcefully administered poison by the petitioner, number 1, my lord.
Statements?
164 statement is there, your lordship.
Victim?
Yes, your lordships. And the allegations against Khuro Shashpuri.
Aunt-in-law.
In this case, yes, petitioner number 2. And actually, the accused petitioner has relation with that lady and forcibly poured poison that was
Is there any
medical.
medical?
Yes, your lordship, I have
which flagged.
That is the allegation.
Unknown poison.
Illicit relationship, that is the allegation.
Allegation. 164 statement
Petitioner has relationship with his
With
aunt.
his aunt, my lord. That is the allegation.
and corroborated the
In the medical before the doctor, any statement that she was administered poison by the accused
no,
prisoner.
that was 164, reflects 164, not medical. But medical,
Charge sheet?
But charge sheet,
Submitted.
instruction not submitted.
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 22.
Third, learned advocate for the petitioner and learned advocate for the state at length. We have perused the entire materials of the case diary as placed before us. It appears that the allegation of torture is privacy omnibus in nature. On perusal of the medical report, bedded ticket, on perusal of the bedded ticket of the victim, we do not find any involvement of the present accused petitioner. Petitioners. We do not find any involvement in the alleged administration of poison upon the victim, at least privacy. Accordingly, we are inclined to allow the prayer.
Lordship,
That
my
the
objection.
charge sheet has also been submitted after completion of investigation. Correct, accordingly.
In the event of arrest.
Lordship, my
10,000
objections.
10,000 with today's just like arresting officer, no, subject to satisfaction of arresting officer for to comply with the further direction that the present accused petitioner shall appear before the learned trial court within 21 days from the date of obtaining certified copy or from the date of uploading of the server copy, uploading of this order in the server, whichever is earlier. We go ahead and get another learned advocate for the petitioner and learned advocate for the state. At length, learned advocate for the state vehemently opposes the prayer for anticipatory. Second part.
41.
But I am for the. But offense under section 363, 376, 109 and 506 of the Indian Penal Code, both are major. The victim lady is a married lady, and my lord, allegation is that on the fateful day, he went to the jewelry shop, my lord. At that time, this petitioner, my lord, took away him in a, my lord, unknown place and subsequent motorcycle.
Motorcycle.
And,
motorcycle, she was
another accused person granted an anticipatory bail by the learned session judge. My lord.
Against this person, my lord, this accused petitioner took this victim to the unknown place and undisclosed place, my lord, and she was raped, my lord.
That is the allegation, my
164.
lord. Kindly see.
And medical is at page 27, but medical does not corroborate the prosecution.
Actually, there is a
Medical
relation.
does not corroborate.
She's a married lady, 25 years.
What is the stage?
Stage is, my lord, charge sheet is pending, my lord.
There is a relationship between the parties.
The allegation is that when the de facto complainant oblique victim was visiting a jewelry shop, comma, the petitioner and another co-accused person took her away on a motorcycle to some unknown place and raped her. Paragraph. The petitioner says that this is a completely false implication. Stop. He has no connection with the alleged incident. Paragraph. We have seen the statement, the material in the case diary. Stop. We have all seen in the stop now, including the statement of the petitioner, victim recorded under section 164 CRPC. Stop. The medical report does not prima facie support the statement of the victim lady. Stop. She is 25 years of age and is a married woman. Stop. Paragraph. Considering the facts and circumstances of the case and the nature and gravity of the charge, comma, although investigation is still in progress, and considering that investigation has progressed substantially, comma, we are inclined to allow the petitioner's prayer.
10,000 to register 5,000 each. Arresting officer to meet the arresting officer once as and when called for till submission in FF.
Item 42. Item 14 for not. 43.
That's your intermediate quantity, Rashid. 5 kg, 500 gram.
And the persons from whose possession the contraband article has been seized, they are on bail, granted by the learned court.
Only 5 kilo and 5 grams. Most unimpressive.
Charge sheet has already been.
And joint possession.
Well, no, not from my possession.
Nothing
my
was
house.
nothing was recovered.
Nothing from
Your name transfers from
FI.
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 The petitioner says that no contraband was recovered from his possession. Stop. In any event, comma, he says that intermediate quantity of contraband is involved and not commercial quantity. Stop. Therefore, section 37 restriction would not be attracted. Paragraph. Now, he further says that co-accused persons from whom the recovery was made have been granted
Bail by the
bail.
learned court below
Bail.
by
the-
order number 5 dated 13th of December 2022.
Likhjo. Charge sheet.
Charge sheet submitted.
Stop. Paragraph. We have seen the material in the case diary and heard learned advocate for the state. Stop. Charge sheet has been has been heard learned advocate for the state who strongly opposes the prayer for anticipatory bail. Paragraph. Considering that charge sheet has been submitted after completion of investigation. Stop. Comma. And the nature and gravity of the charge, comma, we are of the view that custodial interrogation of the petitioner is not necessary so long as he cooperates with further investigation, comma, if any. Paragraph.
My lord, NDPS court. Yeah.
No, it is a 430, no?
My lord.
Charge sheet submitted.
Charge sheet, sir.
Satisfaction of the such and such code. Is a further direction. That's it. It shall remain present. Substantive hearing. Each date of substantive hearing. Subject to the provision of section 317 CRPC.
Grateful, Lord.
44. 44, my lord. I appear for the petition.
What I have for the state.
My lord, the allegation is under sections 399 and 402 of the Indian Penal Code, read with sections 25 and 28 of the Arms Act. My lord, what has happened that in June
Is there any recovery from him?
No.
Heard learned advocate for the petitioner, learned advocate for the state. At length. It is contended. What is the stage of investigation?
Charge sheet submitted.
It is contended that considering the fact that the present accused petitioner has got no involvement in the alleged crime, and considering the fact that the investigation has already been completed, comma, the instant application for anticipated bail may be considered favorable. Learned advocate for the state opposes the prayer. Stop prayer. On perusal of the entire materials of the case diary, it reveals that admittedly there are some incriminating materials as against the present accused petitioner, but considering the fact that the investigation has already been completed in the meantime, we are inclined to allow the prayer. For 10,000 to register like amount, satisfaction CGM Jalpaiguri with a further direction to appear before the learned trial court within a period of fortnight from the date of যেমন হয় সার্টিফাইড কপি অথবা আপলোডিং অফ সার্টিফাইড
32
হ্যাঁ ওটা তো থাকবেই
Grateful.
দেবেন
Grateful, my
always.
lord.
45.
My lord,
on
kindly make it not today, my lord.
46% 1 day accommodation. 47.
I'm appealing for the petition. Actually, the renewal of prayer.
Prior to submit of the charge sheet, the application for anticipatory bail application for.
What is the nature of-
Turned down. Lordship, 302 has been added.
So what is the change of circumstances?
Madam, I'm up to that. Lordship, the fact of the case is that there is a land dispute, Lordship, between both the parties. Both have
Just a
sustained
minute,
injuries.
just show us where is the previous rejection order?
My lord, it's there, it's been annexed with my petition,
Page 21, 22.
my lords.
No, not only.
Page 12. Page 12 to tell us.
Where is the order?
Page 12.
Page 12, your lordship.
No, that's Roshan Ali.
And another.
Roshan Ali is the principal accused who has been granted bail. After,
This is 47. This petitioner is Mamata Bibi.
my lords.
Where
Where
is
is your previous rejection order?
My lords, I was one of the petitioner in the application.
Where?
It's Roshan Ali and another. It's a server generated copy. I was one of the petition.
Oh, this is Roshan Ali.
I'm not Roshan Ali, but along with Roshan Ali.
In that
Roshan,
one.
my lords, my
So
lords.
your order is 18th October 2020.
My lords, my lords.
So what is the change circumstances?
Lordship, subsequently charge sheet has been filed, but
Filing of charge sheet is not a supervening
I'm
circumstance.
coming up to that. During the investigation, the investigating agency has found that there is the role attributed by the petitioner is not attracting section 302, but rather 307. When my application was rejected on the ground that 302 is there, an investigation has not been completed. But the role which has been attributed by the petitioner is 326, 307 of the Indian Penal Code. And
As against you, what in the charge sheet, what sections are there?
Lordship, all the sections, and
Then-
subsequently the principal accused has been granted bail after the charge.
That
sheet has
cannot
been
also
filed.
be a supervening circumstances.
That's
See the
fair.
judgment of the
But
Supreme
your
Court.
lordship kindly sees the observation of the investigating officer when he has filed. Merely,
Circumstances are those circumstances
that's true.
which in spite of best effort, the accused could not place before the court. Or any circumstance which is arisen after rejection of the bail. It is not the
My lord, kindly sees the involvement of mine. Kindly
See,
sees the charge. That's true. What
try
your
to
lordship-
understand the
what has been
predicament of the
followed-
court.
What has been followed.
Where
from
when
your
we are going to pass an order of allowing order or rejection, we have to give a reason.
My-
And that reason become precedent in the state.
my lord,
So we are not supposed to pass any order
Your lordship has followed.
which is not
I
against the
tried
law.
to- I tried to find out, but the problem is that the investigating officer has very nicely put it this section so that I cannot do.
That cannot be the supervening circumstances.
My lords, my lords.
What you do, tell me as rather than
My
reject
my
it.
lord, kindly, on minutes. It's a second application, kindly record the
Come.
submissions. There is no change of circumstances either. It will-
Or learned advocate for the petitioner. And learned advocate for the state. Stop. In course of hearing, learned advocate for the petitioner could not convince us about any changed circumstances for entertaining the instant application for anticipatory bail for the second time, which could not be placed before the coordinate bench while rejection of similar such prayer. Stop. Considering such circumstances, prayer for anticipatory bail, which has been filed for the second time, is considered refused.
Grateful, lordship.
Grateful, my lord.
48.
Worship 40 to praying for a short Passover. Then it comes in Modi Shri Datto was about to virtually appear, but due to some personal difficulty, she couldn't.
49. For the petitioner, my lord. Allegation under section 493, 304B, 34 of the Indian Penal Code, my lord. Petition before lordship, my lord, the father-in-law and mother-in-law, my lord. The principal accused already arrested and granted bail, my lord. My lord, the
What is the stage of investigation?
my lord, charge sheet has been filed, your lordship. Charge sheet filed, my lord. But regarding bail out, not in the bail application, you have, no. You are arrested and granted bail, my lord. The principal accused.
What are the incriminating materials in the CD?
Serious relationship.
Show us.
Yes.
You are the parents-in-law.
Yes, your lordship.
Who is he? 164?
Uncle and one sister. There is a 164 statement.
No, they are not present at the time of
36
she committed suicide. my lord.
sister and 62, page number 62, uncle. And others, 161 statement also stated that they are not providing. the food for-
304B.
Yes, your lord. No, my lord. The
And
allegation
incident happened
304B, but the
within,
she committed suicide.
after marriage.
The PM report.
No, she committed suicide. my lord, instruction.
And your lordships, they are still absconding and waiting for the charge sheet.
What
And-
kind of injury? Burn.
Lordships,
Antibiotic hand.
but one said in 164, there is a one bleeding injury. And your lordships, hanging,
They are not, my lord, eyewitness, my lord. Committed suicide, my lord, hanging. She committed suicide, my lord. And the principal accused, my lord, already arrested and granted bail, my lord.
incident happened.
Or learned advocate for the petitioner and learned advocate for the state. It is contended that considering the fact that the present accused petitioner's involvement in the alleged crime is very much remote and investigation has been completed in the meantime, the instant application for bail, anticipated bail may be considered favorable. While opposing the prayer for anticipatory bail, learned advocate for the petitioner, as for the state, submits that the involvement of the present accused petitioners are found to be prominent in course of investigation, especially from the statements of the witnesses as recorded both under section 161 CRPC as well as under section 164 CRPC. Stop there. On perusal of the entire materials of the case diary, it appears to us that the allegation as made out in the as made out in the FIR, though gets some support from the statements of the witnesses, but basically those are omnibus in nature. Stop. Charge sheet is stated to have been submitted in the meantime. Considering the entire circumstances, we are inclined to allow the prayer. In the event of their arrest, the present accused petitioner may find bail rupees 10,000 with 2 registers your like amount. Satisfaction CGM, at is ACGM Dinata. 432 compliance with the further direction that the present accused petitioner shall appear before the learned trial court within 21 days from the date of obtaining certified copy or from the uploading of the server, uploading of this order in the server, whichever is earlier. ACGM to act on the server copy of this order.
Identity.
My lord, I am for the petitioner. Case under section
I am for the state, your lordship.
406 and 420 of 34 IPC. My lord, the allegation, the petitioner and one co-accused took some document from the de facto.
Have you annexed the written complaint?
My lord,
I have an next. My lord, the 4 years delay of lodging complaint, no explanation. My lord, the investigating officer till to date, no notice served to the petitioner. I relied on Ernest Kumar judgment.
Allegation of 90 lakhs.
Yes, your lordship. My lord stated allegation.
We are also stating allegation.
My lord, I allies. I have. stated-
Misappropriation.
Yes. May I, my lord?
Materials are there.
Yes, your lord. My lord, it is.
Yes, yes,
it
sufficient
is-
materials
It is
are
not
there.
possible to.
Unless you have been taken into custody, how investigation?
Yes, yes.
My lord,
And
my lord, one accused-
moreover, one thing, my lord, cases
My lord,
of cases
my
of
lord, kindly-
17th of June, 17th of June 2023.
My
Early
lord,
stage of early stage,
19
my lord.
2019, the
Total
occurrence was
misrepresentation is
happened
about 90 lakhs,
2019.
your lordship. And entire villagers are involved as victims.
Go surrender before the IO.
My lord,
Grateful,
2019, the occurrence was happened. But FIR lost 17,
Not inclined, sir.
17,
You want to
2030.
withdraw, we'll dismiss it.
No, sir, don't allow him to withdraw.
Yes.
Say, amount huge.
My lord, I would go.
No, no, no,
No.
not after hearing.
Grateful, your lordship.
The allegation is under section 406/420/34 IPC. Stop.
My lord.
The
it-
prosecution
it
says,
did no
paragraph,
notice served.
the prosecution says that the petitioner and co-accused persons gathered huge amounts of money from villagers, promising good returns thereon. Stop. A sum to the tune of rupees 90 lakhs approximately has been collected by the accused persons. Stop. They have been absconding. Stop. The prayer for anticipatory bail should not be allowed. Paragraph. The petitioner says that there was a huge delay in lodging the written complaint. Stop. He is not involved in the matter at all. Stop. Paragraph. We have seen the material in the case diary. Stop. Prima facie, there are incriminating materials. Stop. Considering the nature and gravity of the alleged offense and the possible extent of complicity of the petitioner therein, comma, we are not inclined to extend the privilege of anticipatory bail to the petitioner.
Grateful, your lordship.
Lord, I am for the petition, my lord. Case counter case, my lord. My niece, my lord, lodge a FIR, my lord. Subsequently, my lord, the counter FIR.
Nature of allegation?
Lord, allegation under section, my lord. 143, 325, 306, 37, 307, 365, 506, and of the Indian Penal Code and section 25, 27, my lord.
My
of the
lord,
outside.
just a half an hour pass over, right? Half an hour, yeah.
Pass over me.
Yes, Lordship, I am for the petitioner. The alleged allegations are under section 323, 341, 365, 506, and 120B of IPC. Lordship, before I discuss the merit of the case, please come to page
365.
Yes, Lordship.
So who has been kidnapped?
No, my lord, it is under 341, 325, 506, 365, 120B. So,
Yes, sir.
yes, my lord.
Yes, Lord.
There is.
Who has been kidnapped?
The complainant's husband, Lordship.
Complainant's husband.
Husband, Lordship.
He has been recovered.
Yes, Lordship, recovered. And no attempts has been taken by the IO to serve the notice of notice under section 41A of CPC, Lordship. CRPC.
My lord, no injury report. Case is under investigation. He has been recovered. So case is under only, my lord, if good kind 341, 365 is there, my lord, because there is no injury report. No injury.
What is the 164?
164 of Roshan, my lord, the alleging that he was. My lord, I'll just
Give it to us.
Uttam Singh's name is here.
My lord, Uttam Singh had called the victim on his mobile phone and informed that he's sending one person over and to show him the plot. Then at 1500 hours, Uttam Singh again called and directed the victim to go near radio center where his associate will contact the victim. Then with eyewitnesses, Somal, the victim on the scooty left for destination. Then when the victim was standing in front of the said plot, the said associate of the Uttam Singh assaulted the victim from back on his end with a heavy weapon, and the victim started bleeding and felt nausea. Then a white Mahindra Xylo vehicle appeared and some miscreants got down and forcefully took the victim into the said vehicle.
This is the victim statement.
Yes, my lord.
No injury report.
No injury report.
Charge sheet.
Charge sheet bending, my lord.
Your name is appearing. You have kidnapped and you have assaulted.
No, Lordship. Lordship, kindly come to page 18, Lordship, of my petition.
What is there?
So it's a lease agreement. Lease agreement between the present petitioner and the alleged victim, Lordship.
Huh.
The alleged victim could not fulfill the terms and condition of the said lease, so they filed a complaint against me to stay on the safe side, Lordship. The case is nothing, Lordship. It's just a fabricated allegation.
Prima facie from the case diary, my lord, it seems that allegation occurred, my lord. They received injuries, but injury was not so heavy that is why they did not go to the medical. But eyewitnesses are there, my lord. Page number 19 and 21.
164.
164.
No injury report.
No, Lordship.
Third learned advocate for the petitioner and learned advocate for the state. In support of the instant application for anticipatory bail, learned advocate for the petitioner at the very outset draws attention of this court to the photocopy of the lease agreement which has been annexed with the instant application for anticipatory bail. It is contended that since the de facto complainant could not fulfill his obligation as per the said lease agreement, he has implicated the present accused petitioner in a false criminal case. Learned advocate for the state opposes such prayer. On perusal of the case diary, it reveals that in the statement of the witness, in the statement of the victim, as recorded under section 164 CRPC, though the involvement of the present accused petitioner is found to be prima facie prominent, but in absence of any injury, report in the city, as on this day, as alleged to have been inflicted upon the victim by the present accused petitioner, we cannot rule out the chance of false implication. Accordingly, we are inclined to allow the prayer. In the event of his arrest, 5,000 with 2 days of 2,500 each. Satisfaction arresting officer, 432 compliance. with the further direction that the present accused petitioner shall appear before the learned trial court within 21 days.
Grateful Lordship.
53.
And he shall meet the investigating officer of this case. He shall meet the investigating officer of this case as and when called for till submission in final form.
Within 21 days to পুরোটা দিয়ে দিন।
And I am for the petition.
I'm praying for not today, 53.
54.
54, my lord, I am appearing for the state. My lord, cases of only section is 354 is there, my lord. Cases of initial stage of investigation, cases of 29th of June 2023. Only non-medical section is 354.
Other court person granted anticipatory bail by the learned session judge. My prayer for was stand down. For this reason, I came before you. There is a village enmity. For this reason, this false complaint was lost, madam. There is no specific role.
What is the name of your client?
My client Kalipodo Roy.
This petitioner is the principal against whom the 354 allegation is made out in the FIR. Investigation is still going on.
Considering nature and circumstances, I will cooperate with the investigating agency, my lord.
Is there any overact?
No overact, my lord.
No material of 354. Our learned advocate for the petitioner and learned advocate for the state who has opposed the prayer for anticipatory bail. On perusal of the entire materials of the CD, we do not find any incriminating material to attract the provision of section 354 as against the present accused petitioner at least privacy. Accordingly, prayer for anticipatory bail is allowed. In the event of a arrest, 5,000, 2,005 each, with 2 days to your like amount. Arresting officer, 432 compliance. Within 21 days to meet the investigating officer of this case as and when called for. Till submission in HFP.
55.
Grateful.
One 47, 148, 186, 332, 333, 353, 436, and 506 of the Indian Penal Code, my lord. There is the intercaste marriage. There is a village valley. There is a certain.
Have you annexed the FIR?
Yes, my lord. I annexed the FIR, my lord. The 2 cases was registered, one by the de facto complainant, another by the police personnel, police suo motu complaint. This is the police suo motu complaint, my lord. And which complaint lodged by the de facto complainant, the present petitioner and other parties also enjoying liberty of anticipatory bail by the Honorable High Court.
Just a minute, just a minute. Yes, what is your submission?
Due to political rivalry, I am being the local known face. For this reason, my name transpired. There is in the written complaint, there is 70 to 80% was present in the written complaint.
My lord, that is the injury report of the police personnel. All are simple, my lord.
Simple in nature.
Simple in nature. All are simple in nature. Page 130.
Our learned advocate for the petitioner and learned advocate for the state. It is contended on behalf of the petitioner that since the present accused petitioners are involved in the politics, they have been falsely implicated in this instant case. Learned advocate for the state opposes the prayer. We have perused the entire materials of the case diary. Full stop. It appears to us that the injuries of the victim are simple in nature. Admittedly, there are full stop. Admittedly, there are some incriminating materials as against the present two accused petitioners. But in considered view of us, in considered view of ours, those are not sufficient for rejection of the prayer. Accordingly, prayer for anticipatory is allowed. In the event of their arrest, 5,000 with 2 registration like amount. Arresting officer, 432 compliance. Charge is submitted.
No, ma'am.
To meet the investigating officer of this case, as and when called for, within 21 days, appearance.
Deep note. 56 and 56, I'm paying for not to develop. For the petition.
About the state, your lordship. It is 195A. Before praying for bail, and to draw his lordship kind attention about this page number 13 of my application. Kindly see. A case of 6 POCSO has been initiated against some persons, including the first 3 of petitioners. And they got the privilege of bail with some certain observation. 195A is the creating pressure upon the witnesses for false evidence, and punishment may extend to 7 years.
It's a non-bailable one, no?
No, non-bailable one. Now, can you see your lordship the page number 13 of my application? There is a specific observation passed by the Honorable Coordinate Bench in respect of these first 3 petitioners. Particularly the page number, paragraph number 2.
In this case, section 6 has been added.
In that case, in this case, not. In that case. In that case, section 6.
So what is the allegation? Not to give evidence.
Not to giving evidence. This is the whole omnibus allegation.
In that case.
In that case. Now, kindly see your lordship, the allegation is omnibus in nature. All the petitioners are female. And they still now, the prime accused is absconding. And the petition number 1 and 2 is not the relative of the prime accused given.
Okay.
That has been observed by the Honorable Court's order in the page number 13.
You are alleged to have been threatening them to withdraw that case.
Previous case. Out of grants, because the prime accused is still absconding, and in this case, charges have been filed.
So what is page number 12?
Page number 12, your lordship.
Page number 12?
That is the charge sheet.
No, annexure P2 of your application.
Lordship charge sheet.
That is the order dated 3/3/2022.
Lordship, you have not annexed.
You have annexed.
I have annexed. I have annexed, your lordship. Kindly see the FIR, that is page number 9.
Raiganj police station. Oh, it is in connection with different case.
That is not in that. This is the genesis of this case.
Sir, after obtaining anticipatory bail in CRM 110 of 2022, you are threatening.
That is the allegation. Now, kindly see the observation.
Have I properly understood?
Lordship.
That is what I am telling you.
Lordship. I may be excused, your lord.
I understood late, but when I understood,
I may be excused that I failed to appreciate your lordship properly. I may be excused, your lordship.
Yes. What is there?
161 statement is there now.
Don't threat.
Lordship,
Allow him, but don't threat.
I will. Charges have been filed.
Our learned advocate for the petitioner and learned advocate for the state at length. Learned advocate for the petitioner submits before this court that there cannot be any occasion to threaten the victim of,
That case was under section POXO, my lord.
sir, I know, the victim of Raiganj police station case number 542 of
Rajganj, your lordship.
Rajganj, my lord.
Lordship,
So it has been written as, which is why I'm thinking Raiganj case, how can it be?
Rajganj.
Rajganj PS case number 542 of 2021. It is submitted that such allegation is absolutely false. Per contra, Parijit, an advocate for the state submits that in course of investigation, prima facie materials have been collected to substantiate that the present accused petitioners are threatening the victim of the said case. Stop. We have perused the entire materials of the case diary. Charge sheet is stated to have been submitted in the meantime.
Filed, your lordship.
Stop. Such being the position, and considering the fact this is not a fit case for custodial investigation further, we're inclined to allow the prayer with some stringent condition. In the event of their arrest, 10,000 with 2 registers like amount, satisfaction, CGM Jalpaiguri.
Jalpaiguri.
With a further condition, the present accused petitioner shall appear before the, you belong to the same locality, no?
Lordship, lordship.
Before the
Rajganj police.
IC/OC Rajganj PS once in a week till evidence of the victim is over in connection with Rajganj PS case number 542 of 2021, unless such condition has been relaxed by the London trial.
So one indulgence, all the petitions are female, maybe one.
Male and female are all equal.
Lordship, lordship.
In the eye of law, they all are equal.
If possible, subject to your lordship's correction, maybe once in a fortnight may be helpful for us because they are the daily labors, your lordship.
But they are not afraid of threatening the others.
Subject to your lordship's correction. If possible, your lordship. Lordship, deeply obliged, your lordship. 58.
I've got get to do.
Statement of coerced person.
Lordship,
Nothing was recovered, my lord, and one of the coerced person granted anticipatory by this honorable coordinate bench, my lord. I annex.
Lordship,
Page 11.
what I was intending to say, just this morning I have received the case diary.
Not today.
I have gone through the same. Apparently, it looks like that co-accused statement, but there are CDRs also. So I
You want to consider? Come back tomorrow.
Lordship, item number 59, my senior will appear in this matter, Lordship. I'm fearing for short passover, Lordship.
Item number 60.
Lordship.
I'm trying for not to. 61.
61 will I'm for the petition.
I'm for the state.
My lord, the case is under my lord, section 354D, 448, 376 and 506 of the Indian Penal Code, my lord. The fact in brief is that the victim lady, my lord, she is a married lady. I am also a married person, my lord, staying in the same locality. There was an extramarital relationship between the victim and the accused person, the de facto complainant and the accused person. When the lady was caught red-handed by her husband, my lord, this is the outcome. This is the institution of the case is the outcome of that, my lord.
My lord, this is the 164 statement of the victim.
But since last 8 months, that is there in the FIR. I was talking.
What is there? Have you read the statement?
Yes, there is sufficient material against the petition.
What is the reason for choosing a married lady? That I cannot understand. So many unmarried ladies are there. So you choose one, fix up a relation with her.
I'll advise my client, my lord.
Till their advice, the order is kept pending.
You are married also?
Yes, yes, my lord. I am too married.
Lovely. What is your age?
My lord, I am 34 years and the lady is 35 years.
Brilliant.
But 164 statement does not support your contention, sir.
My lord, but the FIR, if your lordship peruse the FIR, since last 8 months I was stalking her. Then she came to my house voluntarily to help me, my pregnant wife, and then I ravished her. This is the allegation, my lord. Kindly see.
Let me see.
How long in custody?
My lord, around 41 days.
As per 164, this petitioner invited the victim girl to his rented house.
Help my.
And she went. Charge sheet not yet.
Not yet.
Charge sheet submitted.
Oh.
Educational গন্ডগোল আছে। ও নিজে married। ও বলেছে, হ্যাঁ, ও বলেছে যে ওর wife হচ্ছে pregnant। তিনি বলে নিয়ে গেছে। নিয়ে গিয়ে ওর বয়স মানে বেলটা ঘরে নিয়ে গিয়ে সেখানে arrest হয়ে বেল। You are showing me knife.
The petitioner says that he had a standing relationship with the victim lady. Stop. He is 34 years of age. Stop. The victim oblique de facto complainant is 35 years of age. Stop. They are both married. Stop. They are both married people. Stop. Paragraph. The petitioner says that he has been falsely implicated. Stop. He has no connection with the alleged incident. Stop, which is comma, which is a figment of imagination. Stop. Only. Stop. The complaint is an outcome of the husband of the victim lady having caught the victim and the petitioner together in compromising position. Stop. Paragraph. We have seen the material in the case diary, including the statements of the victim lady. Stop. The medical report does not support the version of the victim lady that he was raped. Forcibly raped. Forcibly raped. Stop. Charge sheet has been submitted upon completion of investigation. Stop. We are of the view that further custodial detention of the petitioner is not necessary. Paragraph accordingly.
এটা দিন উকিলকে দিন এটা খুলে গেছে লুজ হয়ে গেছে That's it though. 10,000 with 2 days security appearance before the learned court on each date of substantive evidence 317.
But I am for the petition. And for the state lordship. And only non-billable section is 25(1)(a) and 27 of the Arms Act. But fight between two group of political party during nomination. Total 45 persons are FIR and one Monojit Das Rai was granted bail by your lordship, my lord. I am claiming the parity. And my wife also the candidate, my lord. I have gone through the city lordship.
Is there any injury report?
No, Lordship, and there is no reflection of use or use of arms. Firearm.
Keshav,
His name is appearing in the 161 statement, in only one 161 statement.
But nothing is there to attract the Arms Act.
No,
Nothing is
so
there.
far, there is nothing.
the petitioner says that the incident was a result of political rivalry. Of a political rivalry, stop. The allegations insofar as he is concerned, comma, are false, stop. Paragraph, we have seen the material in the case diary, stop. There are some statements of witnesses recorded under section 161 CRPC, stop. Such statements prima facie do not attract the provisions of the Arms Act, stop. There is nothing specific against the petitioner, stop further, comma. The petitioner says that he is similarly circumstanced as one Monojit Roy.
No, not similarly
He
circumstances.
says,
I apologize. Lordship.
Monojit Roy, who was granted bail by this court on July 5, 2023. Stop. This is strongly disputed by now. The fact that this submission that the petitioner and Monojit Roy stand on this same footing is strongly disputed by learned state advocate, paragraph, be that as it may, comma, from an overall assessment of the material on record and charge sheet,
Not submitted.
material on record, comma, we are of the view that how long have you been in custody?
For 16 days now.
Okay.
26.
He was taken to PC.
We are of the view
Nothing was
that
recovered.
further custodial detention of the petitioner is not necessary, paragraph accordingly.
5,000, 2,500 each. Satisfaction, which court?
CGM Dinhata.
In Dinhata.
ACGM Malad. ACGM Dinhata.
With the further direction. Present applications shall meet the investigating officer of business once in a fortnight. With the investigating officer once in a fortnight till submission in final. 5,000 টাকা দুটো সিউরি।
হ্যাঁ?
রেডি আছে আমি নিতে পারি করবে। একবার তুমি মামলাটা কল করে
CPM matter item number 188.
Yes. Well, I'm for the appellant.
Who is for the
Who is for
appellant?
the-
I'm for the appellant.
who is for the respondent?
Well, Mr. APP and Mr. Mishra is.
Just tell us, because we are now on Wednesday, it's now 3 PM. Can you conclude by today or
Well, today, my lord.
tomorrow? Both of you, otherwise we will not take up.
Tomorrow, my lord, by tomorrow, I'll conclude, I'll submit my notes.
No,
No,
that won't do, that won't do. We have to hear them also. Friday, don't keep Friday in your counting.
Friday is ready.
My lord, may take the file to Calcutta, my lord, the hearing. May
That is our business, you don't worry. But tell us one thing, whether you can, both of you can conclude by tomorrow or not.
By tomorrow, my lord, I can conclude now, my lord, I cannot say, my lord.
Then we will not take up.
No point, then it will be an useless.
We are ready,
I am ready, my lord.
we are ready, but you have on condition that you have to, you both of you have to conclude by tomorrow.
Otherwise, it will be a waste of time.
My lord, state will not take much time tomorrow, so
But tomorrow we can't give you entire day.
not entire day required. my lord. Tomorrow, my lord, if by 4:30, I will take 1.5 hour and tomorrow, my lord, half hour.
I have only short submission, my lord. So
He has a good case, my lord, so his submission will be short.
আমার কোনো আপত্তি নেই।
চলো। Start.
এই সোমনাথ,
Naturally.
শোনো, শোনো, এদিকে শোনো।
Mate, please, your lord.
একটু আগে দেখে এসো।
Lordship, after this one, Paswa matter will be taken up.
If time permits, it is unlikely that time will permit.
Lordship, great Lordship.
Body said that
Bail should continue.
the bill should continue, my lord.
You decide among yourself.
I have no.
Bail should continue, death can wait.
There are 2 sleepless nights, my lord, I have spent for this matter.
We have also read the papers, you know.
We are ready, but it is up to you. What
But Lord,
matters are to
since majority of the members of the bar are not willing that this.
Overwhelming majority.
Then, my lord, the wish of the bar will prevail.
Democracy.
Yes. Okay, my lord, then.
Next circuit.
Item number 63.
Next circuit.
A 3 PM matter as per request of the made at the bar. 3 PM matter as per request made at the bar. Let the matter be placed before the next available circuit.
Next circuit.
Yes, Miller, I am for that.
I'm for the statement.
This is my bail application, Miller. The charges, Miller, under section, Miller, 363, 365, 370, and Miller, 376, 511.
Why not?
An allegation is that Miller, daughter of the defective commissioner was missing, subsequently recovered. And Miller, this petitioner is not named in the FIR. Subsequently, charge sheet submitted in charge sheet, Miller, the petitioner name is transferred. Only allegation, Miller, to attempt to commit attempt 376. And I am in custody
376 is there.
511.
376, 511.
Just
Tried to rape upon the victim, 164 recorded.
That is the statement.
164 statement
I
recorded.
am in custody
Victim.
65 days. 65 days, I am in custody, 65 days.
Charge sheet submitted, lordship. And
Others two
victim
bracket.
age is 19 years. Victim
20
age is 19 years.
20.
In this case, 2 victims, one is for 14 years
And-
and one is 19 years.
Well, they went to Delhi for her own will. Kindly see the 164 statement. And I have submitted that.
Attempt to rape.
Issue.
Recording হয়ে গেছে, attempt to rape.
The petitioner says that he has been falsely implicated. Stop. The victim girl, 19 years of age at the time of the incident, went with him to Delhi
Delhi. What?
on her own volition. Stop. He did not treat the victim girl wrongly or with force at any point of time. Paragraph. We have seen the statements of the victim girl as well as of other persons recorded under section 164.
Yes.
CRPC. Stop. The victim girl alleges attempted rape by the petitioner on her. Stop. Paragraph. We have seen the material in the case diary and have assessed the same. Stop. Prima facie, does not appear that there's sufficient material to incriminate the petitioner. Stop. Further charge sheet has also been submitted after completion of investigation.
Investigation is over.
Yes. Full. Yes.
Paragraph accordingly.
5,000, 10,000 to register COD like amount. Satisfaction landed
ACGM Jalpaiguri.
ACGM Jalpaiguri.
No, Miller, CGM Jalpaiguri. Sorry.
CGM Jalpaiguri
Yes, CGM.
with the direction to appear before the landed trial court on each date of subsequent hearing, subject to the provision of section 317 CRPC.
Get.
Get flush.
Item 65.
I should
Nature of offense?
My lord, kindly seize the list of dates which is there in your lordship. Kindly seize
NDPS.
For a moment.
NDPS.
Kindly seize the list of dates. At the time of alleged incident, I was 19 years old. Till date, charge has not been framed on the ground that the owner of the vehicle could not be arrested. My lords, I have handed over the server generated case status. My lord will sign there. For execution of warrant of arrest and proclamation, arrest of warrant and proclamation since after the filing of the charge. Charge has not been.
Recovery from him?
Yes, your lordship,
Recovery from
79,
the car. Not from me.
79.22 kg of ganja.
So we can direct the landed trial court to
Yes.
speed up the trial and expedite?
For 3 years, more than 3 years, I'm behind the bars. To just wait for a person to be arrested, thereafter charge will be framed, thereafter the trial will be.
So that is why we
My lord, kindly-
will pass a direction upon the trial court.
Again, lordship, I have to approach this court again. Because I do not know whether he will be arrested or not. Because kindly see,
Therefore, to split up the trial,
I do not know, they never used to do so. Since
we
21,
will say so.
my lords,
Yes.
kindly see, since 21.
You were driving the car.
Yes.
No, I was not driving the car.
What were you guarding the ganja?
Yes, yes.
What
Petitioner
were
is
you-
the driver of the vehicle. Petitioner is the driver of the vehicle. your
Driver.
lordship. Yes.
Or learned advocate for the petitioner, learned advocate for the state.
My lord.
Stop. It is contended.
Kindly,
Considering
time frame.
the
Let a direction of split may not be there.
prolonged
It's their duty to do.
pendency, prolonged pendency of the trial before the learned trial court. The present accused petitioner has to remain behind the bar since
2020, your lordship.
Since 17th of
17/5/2020.
May 2020.
Materials have been placed before us to substantiate that learned trial court is waiting for execution of warrant of arrest of the other co-accused person.
Yes.
While opposing the prayer for bail, learned advocate for the petitioner,
Paragraph.
advocate for the state, draws attention of this court to the seizure list, from which it appears that commercial quantity of narcotic substance being ganja was recovered from the possession of the present accused petition. Stop. Such being the position, we are not inclined to exercise our discretion under section 439 CRPC in favor of the present accused petition. Stop para. However, considering the long pendency of NDPS case number 20 of 2020, we direct learned special judge within bracket NDPS Act, which Jalpaiguri,
My lords.
to take steps for split up the trial and thereafter to proceed with the same in accordance with law, with a further direction to make an endeavor, with a further direction to make an endeavor to consider the charge as against the present accused petitioner, preferably within 2 months from the date of communication of this order.
Grateful.
We cannot direct the, because it may be so that you are being discharged. We cannot ask the court to frame charge. You can consider the charge.
My lords, my lords. Grateful lordships.
হতে পারে না? He may be discharged also.
Unlikely.
Item 67 for the petition.
67 here.
My lords, kindly comes to paragraph number 4 of my petition till paragraph number 9. The paragraph 8. Report to it. Kindly see. No, your lord. My lord, in this case, and he sees the FIR, who is the person in front of whom the gadgeted officer, the Caesar has been made, is the superintendent of, the deputy superintendent of police of STA. The memo of arrest has been signed by the independent witness, is charge sheeted witness number 2, even he belongs to the police personnel. No independent witness, nothing. There is a delay of search and seizure. Though it's a huge quantity of commercial, more than commercial quantity, your lordships. But the procedure, it requires to be fulfilled.
Section 50 has been violated.
My lord will cease from the FIR itself. I request my learned senior friend to hand over the case diary to your lordships. Can you seize the charge sheet?
Just tell us which conditions have been, which provisions have been violated.
Paragraph 15. What I have been stated in my paragraphs.
50.
My lord. Paragraph number 4, paragraph number 5, paragraph number 6, 7, 8 are specifically written on the basis of the violation on the part of the investigating agency. If your lordship kindly sees the case diary, then your lordship, it will be clear, much more clear, what are the violations.
What do you say, Mr. Karunji?
Lordship, FIR is not an encyclopedia. Anybody can give just an information, which is first in the point of time, is the FIR. Now, Lordship, regarding pre-arrest, notice of pre-arrest search, it's on page 10.
Page 10.
10 of the case diary. Prior to search, notice has to be given. It is there.
Next.
Next, Lordship, seizure list is page 12 to 17. Joint possession.
Yes.
Inventory was prepared, page 38 to 42.
38 to 42.
38 to 42. The page 116 is very vital, Lordship. It is a prayer before the jail super Malda. It's a racket worship which is functioning in the locality. For another Om Prakash Dahal to bring him into this case, because it's the racket. This person supplying to that person supplying to him. Page 116. Certificate of correctness of inventory, page 149 to 155. Magistrate duly certified. The same certified inventory samples were sent for CFSL. Page 174 is a CFSL report.
What is the recovery?
Recovery, huge quantity of heroin, Lordship. This is a racket. One person, that Om Prakash Dahal at Malda.
No, that's true. Fair
No,
enough.
no.
That's
Charge sheet submitted, trial began. Already witnesses have been examined.
I'm not on that. That's whether I should be enlarged to be. But the proceedings.
You're not on that, whether you should be enlarged on bail. You're praying for bail.
That's true. Fair enough. The illegality, what my friend has shown to your lordship that the magistrate has given this and that. My lord, can you see the FIR? From where the case has begun, it's not a matter of 302 that or 304.
Not this one. Ishwar. The
13 packets, 6,728 grams of heroin. This is more than 6 kilos.
The petitioner says that he has been falsely implicated. Stop. He is in no way, he has no truck with the incident. Stop. Paragraph, the prosecution case is that 6,728 grams of heroin in 13 packets was recovered from the possession of the petitioner.
Lordship, joint possession.
Joint possession of the petitioner and other accused persons. Stop. Paragraph, the petitioner says that section 50 of the NDPS Act has been completely breached. Stop. It is mandatory to comply with the provisions of the provisions of section 50 of the Act. Paragraph, we have seen the material in the case diary, including the Caesar list and the memo of arrest. So, prima facie, we do not find any serious infraction of the provisions. Infraction of the provisions of section 50 of the NDPS Act. Stop. We are also told that trial has begun in the meantime. Stop. Accordingly, and also in view of the restrictions in section 37 of the NDPS Act, we are not inclined to grant the petitioner's prayer for bail. Stop. Paragraph, however, we clarify that the observations made in this order are tentative and only for the purpose of disposing of the present application for bail. Paragraph, disposed of.
Grateful, Lordship.
I'm for the state, my lord.
I'm for the petitioner, lordship. Lordship, NDPS case, lordship, 41B, lordship, not complied, lordship, column tail.
Empty.
Empty not filled up by the
empty, madam.
complainant. Complainant himself put his signature.
Hey, 33 একটা আছে order. তুমি নিয়েছো ওখান থেকে এখানে column 10 টা লিখবে ওখানে ছিল blank ছিল এখানে লিখবে column 10 has not been signed by any independent witness
or relative
of the accused, but by the complainant himself. Stop. This is complete violation of section 41B CRPC. Allowed.
Deeply.
Section 10, whose signature is there? Kopil Dev Singh.
Kopil Dev Singh is the assistant manager of Interglobe Aviation Limited.
Complainant.
He apprehend the petitioner.
De facto complaint.
De facto complaint.
De facto complaint.
Complaint de facto complaint.
69. 69.
Crossover. It's the first call too.
Not today, lordship.
69 you are the petitioner.
I am for the petitioner.
Oh,
Nobody has.
not today.
Not today.
Item 17.
For the petition.
Lordship, the petitioner is in custody since 18th of March 2022. That is for more than 1 year, 3 months.
There is only ground.
No, Lordship, there is nothing recovered from the petitioner. Who accused it?
Is it correct?
My lord, page 87 of my case diary, my lord.
Caesar list.
No, my lord, the forwarding report from which it reveals that, my lord, this petitioner's name has been revealed from the custodial interrogation of an accused.
Who accused? That's what he's saying.
Lordship.
Caesar list names him, no.
87.
Caesar, from his possession, my lord, 680 gram, my lord, the brown sugar has been recovered from his possession,
Petitioner's position.
petitioner's possession.
What is the name of the present accused petitioner?
My lord, Thakur Shah, alias Veer Shah.
Or learned advocate for the petitioner, or learned advocate for the state. It is contended that nothing was seized from the possession of the present accused petitioner to implicate him in the instant case. In course of his submission, learned advocate for the state draws our attention to page number 87 of the case diary, wherefrom it appears that the name of the present accused petitioner transpires from the version of one who accused. Stop. Caesar list. Where is the Caesar list?
My lord, Caesar is, my lord, page 14, 50 and 58.
Page?
My lord, first 14, 1-4.
Another submission is there, Lordship. Mukhtar Alam, from whose statement the petitioner was arrested, granted bail by this honorable king.
And thereafter, my lord, page 50 and 58.
You tell us from the Caesar list, does the petitioner's name appear in the Caesar list?
No, my lord.
No Caesar from him.
Stop. Nothing has been stated to have been seized from the possession of the present accused petitioner. Stop. Considering the circumstances, prayer for bail is allowed. 20,000 with 2 days or 10,000 each. Satisfaction, learned judge, special court, within bracket NDPS Act, Jalpaiguri, in connection with NDPS, in connection with the aforementioned case, with the direction to appear before the learned trial court on each date of substantive hearing, subject to the provision of section 370 CRPC, with the further direction not to leave the territorial jurisdiction of the learned trial court till conclusion of the trial, unless such condition has been relaxed by the learned trial.
71. I'm appealing for petitioner. 402 gram heroin was seized. I'm in custody for more than 7 months.
Recovery from him, commercial quantity.
Column 10 is there.
I learned advocate for the petitioner and learned advocate for the state who opposes the prayer for bail. Full stop. On perusal of the entire materials of the CD, it appears that commercial quantity of contraband was seized from the possession of the present accused petitioner. Considering such circumstances, prayer for bail is refused.
Grateful, Lordship.
72.
70, I'm praying for not to develop.
73.
73, my lord, I am appearing for the petitioners. Now, these petitioners were arrested on 11th of November 22 I'm not coming to the case. This investigation can be called many things, the least of which is laughable, my lord. I'll draw your lordship's attention to firstly to the FIR, my lord, at page 11. Para 1. This says 50 bottles of codeine phosphate and maleate syrup, Escov cough syrup, each bottle containing 100 ml in composition. Each 5 ml contains codeine phosphate, chlorpheniramine, maleate, flavored syrupy base.
Come to the point, sir. Come to
In
the
different
point.
batch number. Now, my lord, if my lords kindly comes to the seizure list at page 13.
Your joint position.
Point number 5 describes the seizure, my lord.
Huh.
You will find there are no batch numbers. 50 bottles of cough syrups
Oh, sorry.
are being seized, my lord.
Huh.
I fail to understand how will this go to trial? How will the contraband be identified, my lord?
Very good. Next.
The further submission, my lord, this alleged contraband that has been seized does not fall under NDPS Act.
Why?
I'll
Codeine phosphate is not an
my lord,
contraband article.
this Escov cough syrup is not contraband, my lord.
Who is
I'll satisfy your lordships. Kindly bear with me. This is going to be a little mathematical. I draw your lordship's attention to, my lord, page 34 of my petition, my lord. Point number 35.
34.
Yes, my lord. Page 34. This is a gazette notification by the central government under section 211 B of the Act, my lord. So this notification at point number 35 says what will be regarded as contraband under NDPS. So point number 35 says methyl morphine, commonly known as codeine, and ethyl morphine and their salts, including dianine, all dilutions and preparations except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of drugs per dosage or unit, and with a concentration of not more than 2.5% in undivided preparations and which have been established in therapeutic practice. My lord, this Escov cough syrup, each 5 ml of which is a 1 spoonful, contains, my lord, 10 mg of codeine, which is 0.2%, my lord, which is much below the 2.5% as has been enumerated in this notification. This notification says that
will get.
My lord, the point that I just read out at
No, that is
2.5.
yes, my lord, I'm coming to that. Seizure list, my lord, page 13. Kindly see the description. The description says 50 bottles of codeine phosphate, and it describes it. And each 5 ml, which is 5000 mg, contains codeine phosphate IP 10 mg. So the codeine phosphate's quantity is 10 mg out of 5000 mg, which is 0.2%, my lord.
That is not sacrosanct, sir.
No, my lord, this if this is not
That is not sacrosanct.
if this is not
FSL report is the sacrosanct.
no, my lord, but
They are non-technical person.
No, I am not disputing the presence of codeine. I am disputing the presence of the quantity of the codeine, my lord.
Percentage.
Yes, my lord. It says 2.5%. So below 2.5% is not contraband, my lord. Every 5000 mg of this syrup contains 10 mg of codeine.
The seizing officer is not a chemist.
No, my lord. I am challenging the article itself. This article does not fall under contraband.
Take this point during trial.
No, my lord, but I am suffering custody for so long, my lord. I've been arrested.
This is
11 now.
This is not a mathematical. This is a question of chemistry.
If the central government is coming out with a notification and saying that such a compound will not be contraband.
So seasonally shows the seizure of certain items,
Yes.
which comes under the purview of the contraband.
No, my lord.
Just a minute.
Yes, my lord.
But provided that if the percentage is going down,
Yes.
it will go out of the rigid of the
NDPS Act. NDPS Act.
But that will be evident from the CFSL report.
No, my lord. The CFSL will only say whether codeine is present or not. The CFSL will only say that.
Safe harbor has been filed, my lord.
But this description,
What is your submission?
My lord, thing is that the entire, if there is a percentage of contain, as per the NDPS Act, the entire syrup will go, my lord. That is the settled principle of law. Regarding the Caesar list, I do admit that there are batch numbers are not there. This is like a peculiar case where I first time I've seen that batch numbers are not there. Generally, batch numbers are there. So those matters.
Lord, I fail to understand how will this go to
No,
trial?
what is your submission with regard to the percentage?
Percentage, that is settled principle in the NDPS Act. The entire mixture will go. What percentage, whatever percentage is there.
Where is that? Where is that?
That's in the NDPS Act.
In the schedule, in the schedule.
In the schedule.
NDP accepted schedule.
Say to schedule.
Item number, schedule, item number.
The last one, madam, last one.
Just about.
Salts and preparation of the above. 111.
4, 7. The small quantity, it's after 239, serial number 239.
এটি দাও তো গো।
The quantities.
Schedule
ওই যে উনি
এগুলো
দিচ্ছেন
দিচ্ছেন দিন না। List of psychotropic substances. Any mixture or preparation of that with a neutral material.
My lord, the schedule was so satisfactory, then there was no need for this notification, my lord.
Notification is over which date?
My lord, the date is,
No, act will prevail over the notification.
the date is, I'll just point out here. My lord, 14th of November, 1985. Right after this act, my lord. My lord, if there isn't a doubt, my lord, then I'm seeking to not press this application.
We have no doubt. We have no doubt in rejecting your prayer, but even if we are giving you the opportunity.
I'm appealing for the.
Lord, 74, my lord, I am praying for 1 day accommodation.
All right.
75.
Violation of section 41B, my lord.
Blank or the complainant himself has signed.
Lordship,
Column 10.
Yes, your lord.
Lordship, if the term locality can be given a wider aspect of society, then Inspector Nand Kumar will come as a respectful person of the society. Lordship. Here, column 10 is signed by the inspector himself.
The 12th April, there's a rejection on the same ground you took. How can we know?
My lord, kindly, my lord.
What kindly?
Like he then casted 372 days in. my lord.
Coordinate bench, same ground he had taken, 12th April.
373 days in casting, my lord.
Lordship, in my copies, January and February.
But the other co-accused already granted anticipatory bail, my lord. My lord, kindly, my lord. The petition is.
Lordship, in my copy is January and February.
না না এটা এটা লাগানো আছে আগে আগে 8 নম্বর
8 নম্বর কথা
Oh, this is Justice Bharadwaj.
Yes, your lord.
Lordship, this is that Colonel Singh.
Who signed this?
The Inspector Nand Kumar. This is that condolencing I have handed over to my lord. This is this. Lordship is relative or respectable. It is nowhere mentioned that independent.
No, if he is a respectable person of the locality, he ought not to have signed by using his designation.
Designation. We have Nand Kumar, we don't have Elijah MP, Lordship, my lords.
But the learned, with due respect, the learned coordinate bench has not considered the DK Basu's judgment. So, sir,
Yes, Lordship. It was not considered. Only coordinate bench judgment they have referred.
33. Memo is signed by one
Police official.
police officer. Stop. This, in our opinion, is not sufficient compliance with the requirements of section 41B, capital B. Accordingly.
Grateful, Lordship. Our hands are tied. Lordship.
Naturally. Now, Mr. Ganguly, we rightly or wrongly, we have taken a view, so we have to stick to
Yes,
it.
Lord. And Lordship, our role, I have to play.
Of course.
Item 76.
But your friends must be happy with that.
Sure, no.
Your friends must be happy with that.
Lordship.
যদি কনফিউশন একটু দেখিয়ে নেবেন আমাদের কারণ আমার টানা ওই ওই যে কোর্টে আছে সেই কোর্টে ও সব ওখানে লেখা আছে সব লেখা আছে
76.
I think I'm 76 clear for nothing, Lordship. Not today.
77.
Hello, I'm for the petition.
My lord, I am for the state, my lord. Here is 41B is violated, my lord.
Violated.
Column 10 is blank, your lord.
Blank.
সেম 30
33, ekdam 33.
My lord, what will be the bail bond?
20,000 or 10,000 something like that.
My lord, since the petitioner was a coolie, so my lord, if it is,
Let make it 5,000 with 2 registered security like amount, other conditions will remain same.
my lord, great. Deeply obliged, my lord.
Considering
Kindly note our
considering the financial distress of the present accused petitioner as stated by learned advocate for the petitioner.
Deeply obliged.
This is a pro bono case for you.
My lord. My lord. Great.
78.
78, 79, I'm paying for not today, my lord.
Column 10 is all right here.
Item
So what will be good of keeping not today? Make it not circuit, not this circuit,
Not today. Only not. Only not today.
not this circuit,
Not today, my lord. Only not.
not today.
Item 80.
My lord, I'm for the petition, my lord.
NCB.
Yes, what is the ground?
Statement of co-accused person I implicated in the
No
incident.
recovery,
No, my lord, no recovery. 3 other co-accused person, my lord, granted bail
Caesar list.
and not from other person, my lord.
Lord DSG, is his claim correct?
My lord, I am not on his claim, correctness of his claim. What I'd like to impress upon my lord is one judgment of the Honorable Apex Court. Reported in 2022 3 Apex Court judgment, Supreme Court 565. And another one, my lord, of 2022 of the Apex Court. Now, this, my lord, Union of India versus Khaliluddin.
Non-recovery.
3 other co-accused person granted bail in this case, my lord, by this honorable high court. One is co-accused person and another 2 are principal accused from them recovered. They also enlarged on bail, my lord. 4 accused out of 3 are on bail. I am the last person, my lord.
So you should be released on bail. Because
This
you are
also
last
my-
person.
This is also my another submission, my lord.
Brain things. Dinto.
A statement of co-accused person, my lord. Your lordship also granted bail in other occasion also, my lord.
Let us see what the Supreme Court
Yes, my lord.
says.
Khaliluddin ये थे बात को.
Which case? Huh. But he was the owner of the car.
And
Apart from the name of the co-accused, he was the owner of the car.
in this case, he is the owner of the goods.
Owner of the?
Goods.
No, owner of the goods and owner of the car is.
No, my lord. He is the person who controls the entire exercise of transporting, selling. The entire business is the key head.
That is the subject matter of trial.
So let him prove in the trial, my lord.
Different facts.
Which page?
My lord, in the other cases where the orders of the co-accused he is referring, my lord, this judgment was not awarded to.
No, the other one,
In the Indresh Kumar is, my lord, I only wanted to impress that statements which may not be admissible in trial, but in the stage of hearing of bail, though these are relevant. My lord knows Justice Banerjee.
not NDPS case.
My lord, that is a general
law. Or learned advocate for the petitioner, learned advocate for the NCB. At the very outset, learned advocate for the accused petitioner. Draws attention of ours to the order dated 24/20/2021 as passed in CRM number 332 of 2021 by a coordinate bench stop. It is contended that considering the fact that the present accused petitioner's name transfers from the statement of a co-accused and considering the fact that the present accused petitioner is similarly circumstanced with the accused person already enlarged on bail by order dated 24/20/2021, the prayer for bail may be considered favorably. While opposing the prayer for bail, learned DSG places his reliance upon two reported decisions, namely Union of India versus Khaliluddin, reported in 2022 within bracket 4 RCR within bracket RCR আমি দাগ দিয়ে দিচ্ছি RCR within bracket criminal 984 and Indresh Kumar versus State of Uttar Pradesh, reported in 2022 within bracket 3 RCR criminal 1003. In course of his argument, learned DSG submits before this court that in the case of Khaliluddin Supra, the Honorable Appeals Court, in a similar circumstances, rejected the prayer for bail. Whose complicity was in the alleged crime was found on the basis of a co-accused statement. We have considered the rival submissions. We have also perused the CD. We have also gone through the reported decisions cited from the side of NCB. In our considered view, the judgment of Khaliluddin, the reported decision of Khaliluddin, bracketed Supra, is distinguishable in view of the fact that in the said case, the respondent was found to be the owner of the vehicle through which contraband articles were alleged to have been transported. So far as the reported decision of Indresh Kumar within bracket Supra is concerned, it appears to us that the case involved therein is not at all NDPS Act. In view of such, we are constrained to hold that the aforesaid two reported decisions as cited from the NCB are quite distinguishable from the facts and circumstances as involved in the instant case. Stop there. It appears that in the earlier order dated 20/4/2021, as passed in CRM number 332 of 2021, one co-accused was enlarged on bail considering his arrest is based on the statement of a co-accused. Stop. in order to maintain judicial propriety. We are thus constrained to hold. We are thus of considered view that the present accused petitioner is similarly circumstanced with the accused person already enlarged on bail in the aforementioned case. Accordingly, the present accused petitioner may find bail of rupees 10,000 with 2 registered seat like amount. Satisfaction learned additional session judge within bracket special judge NDPS court, NDPS Act, second court Jalpaiguri. With the condition that the present accused petitioner shall appear before the learned trial court on each date of substantive hearing, subject to the provision of section 370 CRPC, till conclusion of the trial.
Mr. Mujumdar, the facts of Indresh Kumar were terrible.
My lord, yes, my lord.
Terrible facts,
Terrible.
heinous facts.
Heinously, there is no what to describe how the murder was committed.
আমি এগুলো দাগ দিয়ে দিয়েছি জানেন, একটু দেখে নেবেন আপনি। এই যে সাইটেশন গুলো দাগ দিয়ে দিয়েছে, দেখিয়ে।
Item 81.
বাপরে।
82. Item 82.
That too, where 2 cases have been initiated against this petitioner within a gap of 2 days. He was first, a case was initiated under section 379, 19/11/2021. All the newspaper articles were stating that he has been arrested in this case. But police is stating after 2 days, he has been arrested in a case of NDPS. And recently the PW1, which the complainant has deposed in court, that is totally damaged the case of the prosecution. He has clearly stated that the petitioner was carrying the contraband article on the fuel tank in a cartoon box.
Sir, 2 rejections, one in February,
Yes,
one in April.
Yes, sir.
Evidence was done recently and it has totally damaged the prosecution. After this.
What? Show us that.
Yes, yes.
What has damaged the prosecution case?
PW,
PW1, complaint.
page,
In my cross examination.
page.
Page number 30. Last paragraph. Actually, against the backdrop that 2 cases within after 2 days. 379.
All right, come to the merit of this case.
The accused person was holding the cartoon box supported with his legs kept on the tank of the motorcycle. This is absurd. It cannot be done. Why? There was cup syrup in the bottoms of the cartoon. The cartoon box was next to the courtroom. The cartoon box was not seen. It was not present in the courtroom. And he was resting his legs on the footrest, still holding the cartoon box in full tank. Is it possible? Impossible.
Make this argument for the trial court.
Yes, sir.
Can we appreciate evidence?
My lord,
Sir, this is not the proper forum to appreciate the evidence.
my lord, is
Then with the provisions of appeal are to be given good by sir.
consider one thing, my lord, that
There are other witnesses, lordship, just PW1 was examined, lordship.
19.
Sir, I know you are making a frantic attempt to get a favorable order. There is no doubt of it, and there is nothing unethical. But
Actually,
just tell us in a while adjudicating a bail application, can we appreciate evidence? Then
But the thing is that the newspaper article, 2 newspaper article I have annexed, they are stating that he has been arrested on 19th.
Very well. Do you want us to pass an order or you want to not press?
Not
আমি এসব evidence কি করে পাবো?
Item 83.
Lordship, item number 83, I beg to appear on behalf of the petitioner, Lordship.
Date 83,
Lordship, I'm praying for not today.
days accommodation, Ms. Dotto.
Lordship.
Item 84. Behalf of the petitioner, my lord, I am praying for the next.
Next cycle.
85.
85. Column 10 not complete. 85.
85, column 10, blank. Blank.
85 my lord, column 10.
এই অপূর্ব 33 আজকে আইটেম 33 যে অর্ডার হয়েছে সেটা হবে 85 এর। হ্যাঁ ঠিক আছে।
Same order as item number 33. Column number 10 is blank. নোট করে রাখুন। বুঝতে পেরেছেন? অ্যালাউ হবে সেম কন্ডিশন।
86.
Lordship, kindly page number 15. The scissor list in connection with this case, there is a scissor witness, Nozul Islam. And Lordship, page number 17,
What is the previous page?
15,
15.
15. The independent witness is Nozul Islam.
Independent is Nozul Islam and
And page number 17, Lordship.
Huh.
is another NDPS case of this particular police station. There is also this Nozul Islam is an independent witness, Lordship. This Nozul Islam is a permanent independent witness of this PS, Lordship.
No,
All can fabricated-
is a permanent respectable person.
Lordship,
You can learn your adversary can say is a permanent respectable person who is always cooperating with the administration.
And also Lordship, memo of arrest column 10 by this Nozul Islam, Lordship.
No.
6,000 pieces of yaba dhal.
No, not this one. Withdraw. Not pressed, huh?
87.
87 may request not to be managed.
88.
Particular case. In this particular case, Lordship, I humbly beseech my lords to show some magnanimity, Lordship, the present petitioner before you, Lordship. She has a 6-year-old son. Lordship, of medical documents, the son is suffering from, he's a terminally ill patient. He's suffering from thalassemia. And
Suffering from?
thalassemia, Lordship, blood cancer, Lordship. The son, the 6-year-old son of the petitioner, Lordship. The only thing I'm praying for is to my lords to show some magnanimity and stringent conditions may be imposed upon the present petition, Lordship. She's a single mother, my lord.
Right, there's nobody else to.
No, Lordship, she's a single mother, there's nobody else.
Difficult decision.
Lordship, any condition, any stringent condition.
What is the recovery?
301 gram brown sugar, my lord. 250 is a commercial quantity.
Lordship, kindly, Lordship, Lordship, the only.
142, please go up, Supreme Court. We can't.
Lordship, the
We
only
can't.
reason this child is 6 years of age.
We
Lordship.
appreciate, we
And
sympathize.
Lordship, the recovery was not from just, it's a joint recovery, Lordship. She
Very
was
well.
traveling in a car with 2 other persons, Lordship.
The petitioner says that her only child, 6 years of age, is suffering from thalassemia. Stop. There's nobody to look after the child. Stop. Some mercy should be shown and the petitioner should be released on bail on most stringent conditions. Stop. Paragraph 301 grams of brown sugar was recovered from the joint possession of the petitioner and other accused persons. Stop. In view of the restriction in section 37 of the NDPS Act, we are not inclined to exercise our discretion to grant bail. Stop.
Therefore, it is rejected.
Accordingly rejected. আচ্ছা শোনো একটা দেখুন একটা দেখুন while we sympathize with the petitioner এটা আগে দেবেন rejection comma sympathy cannot be the ground or basis for passing orders in courts of law.
89.
I'm for the state, my lord.
The petitioner, during the pendency of this application, also the co-accused petitioner has been released on bail by his
এইটা হয়ে গেল।
Sorry,
My lord.
will you repeat your submission?
My lord.
During the pendency of this application, also co-accused petitioner has been co-accused has been released on bail by this honorable High Court. Also, I am saying for parity on the ground. This is the order.
My lord,
No recovery from him. No recovery. This is also
recovery from him.
But
My lord, raiding party signed the seizure list and the arrest memo. No independent witness.
No independent witness?
No, my lord. This is the seizure list and arrest memo also there, my lord. Constable and of the raiding party is
Jesus. What party?
raiding party, my lord. Who raided the
Raiding party,
yes, raiding party,
not independent.
not in the.
Memo of arrest to the constable. Co-accused also released on bail.
What about the parity he is claiming?
Shivaji is pending. Oh, sorry, it's allowed. Same.
Same.
It's allowed.
But it was granted on a different score.
Oh, 41B, same issue.
No, FSL report.
FSL report.
Subhash Yadav.
Subhash Yadav.
Subhash Yadav. And apart from that memo of arrest, her learned advocate for the petition, learned advocate for the state. And in course of hearing, learned advocate for the petitioner draws attention of this court to the order dated 5/7/2023 as passed in CRM NDPS number 488 of 2023, whereby and whereunder one co-accused was enlarged on bail by this bench. It is contended that the present accused petitioner is similarly circumstanced with the accused person already enlarged on bail in the aforementioned case. Learned advocate for the state, though opposes the prayer, but he also does not dispute about the footing of the present accused petitioner with the co-accused who has already been enlarged on bail by us. Such being the position, and on the ground of parity, we allow the instant application for bail. এবারে এখান থেকে যা আছে সেট আউট, খালি নামটা পাল্টে যায় ভাই, নামটা লাল কালি দিয়ে দিয়েছি, ওটা আবার ছেপে ফেলবেন।
Item 90. 91.
It's not with that, I'm feeling uncomfortable. It's not so unwell. Yes, sir.
Lordship, I have column 10.
Column 10. 33, soon.
Wastage of time.
Column number 10.
Sorry.
Blank, same as item number 33.
Bail condition or same show.
যা যা আছে সেম যদি বুঝতে অসুবিধা আমার কাছে জেনে যাবেন কিন্তু আন্দাজে টাইপ করে দেবেন
22.
For the petition, Lordship.
Lord, the case diary has yet not been reached.
not today.
My lord, this matter has been running in the list since last week. My lord, kindly a direction may be given to produce the CD so that we can conduct a hearing.
Sometimes request is better than direction.
My lord, I have been requesting my
For the last
elder brother.
for the last 13 or 14 days we are passing directions and orders.
My,
Let
my-
them
we
let
are
us take a
grateful for
chance
that.
of making a request.
My lord, only one day, as per my lord's convenience, only one day of circuit is remaining.
You go out of court, give him a big hug.
I will, just right now, I will. Just right now. But kindly, my lord, direct the state to.
Let's try to ensure
Tomorrow.
Tomorrow.
tomorrow try to
let's-
ensure convey the anxiety of ours to the IO.
Lordship.
Item
I'm great.
93.
Hey, ask me.
Okay, well, not today, my lord.
ও আমাদের কাছে আর মামলা করে।
94.
Well, I'm for the petition, madam.
For the state.
My lord, the petitioner. Yeah. My lord, the petitioner's Aadhaar card was used for sending some parcel wherein some quantity of ganja was recovered, my lord.
How much?
My lord, it's about 87 kg, my lord.
That is why you didn't mention the quantity.
My lord, it was not found from his position. He resides in a remote village of Bihar, my lord. My lord, only his Aadhaar card, that too Xerox, not his signature was available from the booking slip, I guess, my lord.
He's in the habit of going around circulating Xerox copy of his
My lord,
Aadhaar card.
this might have been obtained from a Xerox center where he has applied for seeing anything like that, my lord.
What is there? Anything recovered from him?
No, my lord. Only the contraband booked by this petition.
Where? With booked whom? With whom?
RPF.
RPF.
NGP from NGP station. New Jalpaiguri station, my lord.
New York, it was in parcel.
Yes.
No,
my
my lord, not in person, my lord. He's-
Parcel, my lord.
But it was booked in his name
In his name.
as a sender.
Yes, my lord.
Using his Aadhaar card, my lord. Xerox copy.
What are the other materials against him?
There is other matter.
Give us the study.
And I'm in custody for more than 450 days, my lord. Charge sheet has already been submitted, my lord.
What is your name?
Chandan.
Chandan Kumar. Where's the material of booking the parcel? Page?
Page, my lord, there is no pagination, my lord.
Pagination is there, sir.
40th. From the package of
Only, there is only one thing, my lord, it was found that those packages were booked by one Chandan Kumar. And it reflects that the Aadhaar card belongs to this person, this petition. And Caesar list of one Shivaji something, my lord. Shivaji Kumar. Kindly, short possible, my lord. I will mark the page, my lord.
Any TI pattern has been done.
No, my lord, that I have to just
Making it not today.
okay.
Come ready on tomorrow. Because as if he has been identified by the booking clerk, the position would have been otherwise.
Yes, my lord. I will not today, ma'am.
Yeah. Just check it.
Yes, ma'am.
I have instruction that no TI period has been conducted.
No, give me.
No TI period has been conducted. I have instruction that.
Let him come.
Yet full loss.
95. Well, I am for the state.
95. I'm for the petitioner, my lords. Lords, kindly see the last rejection order, the last page of the application, my lords. My lords, the one extension was filed by the prosecution solely on the ground of unavailability of the forensic lab report. My lord, we have agitated our ground for bail. However, it was turned down by the learned trial court.
My lord, charge sheet was submitted, my lord, on 10th of August 2022.
Beyond the statutory period.
Look, that no, within the statutory period, within the
Without FSL report.
without FSL report. Within the extended period, it was done, my lord. And thereafter, CFSL report has also been filed, my lord. It is in the case diary.
No.
Granted only on the ground of non-availability of the.
Yes.
That is what Subhash Yadav is, not one of
Yes.
the grounds.
But my lord, here the extension was prayed, and thereafter it was charge sheet was filed.
Yeah, that's all right, but then he's entitled to statutory bail then.
Has he prayed for?
Yes.
And
What is that?
On the first paragraph of the order sheet, my lords.
No, that was only a bail petition, not a statutory bail petition.
My lords, kindly see the
Sufficient.
Oh, my lord, there has to be a.
kindly see
reflection that
the
it was-
third paragraph
it was
of the
on
order, my
ground of
lords. We have,
statutory bail.
if I'm permitted, my lords, kindly see the third paragraph of the order. We have objected on the extension prayer, my lords. and prayed for
Read out.
My lord, I'm reading the paragraph where we have the learned special PP in charge prays for extension for the prayer of investigating by 90 days as the IO is unable to submit the charge sheet due to want of chemical report. Learned lawyer for the accused raises objection and prays for extension for the period of investigation only for 15 days, my lords. That's the relevant part. My lords, if I'm permitted, the learned trial court has also opined that though it is not legally barred to submit the charge sheet without the chemical examination report of the alleged articles seized, but at the same time, charge sheet without chemical examination report cannot be regarded as sufficient to proceed. My lords, the learned trial court in itself opines that it's not actually barred. However, my bail was turned down and my statutory right was curtailed, my lords.
That was not a statutory bail application, my lord.
My lord, that
There
was
is
a
no
statutory
reflection
bail
in the order.
application.
It has to be specifically a statutory bail order. Even if a oral prayer is made, my lord, that there has to be a reflection in the order sheet. Neither oral prayer nor written prayer was made that it was a statutory bail application, my lord.
Which authority says so?
He is Subhash Yadav, my lord. Subhash Yadav also only says, my
The
lord.
word statutory has to be used.
Yes, they have to
Use
pray
that.
for statutory bail, my lord, because
They have filed this bail application well.
After the
Immediately after expiry of 180 days.
no.
And that
Expiry-
becomes
within the statutory time period. It was not expired on 27/6/2020.
On the expiry of 180 days, there was a bail application on record.
My lord.
It says that on the day of passing the order, the statutory period was not over.
Not over.
Not
Not over. Not over.
over.
It was 180th day, my lords. And that was the last day.
That was
That was the last day.
So then you had not become entitled to
Yes,
statutory.
yes. Then, my lords, kindly grant me the leave to let me appear. My senior will appear in the matter, and he will.
Not anymore. We've heard you, sir, indeed.
My lords, my lords,
heard you.
I pray for mercy before
It
you.
can't be improved. 180th day, they had 1 day left. Please,
My lords, then I'll allow me to not press this application if
Yes,
my lord
that you
presses.
can.
that you can.
180 days করলে তো হবে না 181 days কি করবে?
I'm grateful, my lords. Grateful.
96.
Lordship, I'm for the petitioner.
My lord, not today, my lord.
CD is not available.
CD is not available.
97.
All my cases are petitioner not to be.
State
I beg to appear in item 97 minutes. This is a case that's squarely false. There's a judgment. My learned.
1 second. State, ache?
Just it. My lord, I'm praying for 1 day's accommodation. my lord.
Not today. Not today. He could very much that the second full.
No, they have to order completely. Restriction.
98.
Not today.
99.
I'm for the petitioner.
Lordship, it is not available. Century.
100.
100, my lord, I appear for the petitioners, my lord.
You appear?
Yeah, I'm for this.
My lord, the allegation against the petitioners is under section 406, 420, 467, 506 and 120B of the Indian Penal Code. The allegation is that the petitioners had taken money from the de facto complainant on the pretext of giving him employment in the railways, Indian Railways. My lord. That is the complaint. If your lordships will kindly come to page 11 of my petition, my lord. The de facto complainant had taken 3 lakh rupees from the petitioner number 2 as a loan. On 18 February 2018, with an understanding that in 24 months, my lord, he will return the money. Now, this money was not returned. The petitioner number 2, my lord, tried to recover the money. He somehow, my lord, on one pretext or the other, delayed it. Thereafter, if your lordship kindly comes to page 12, on the instruction of the petitioner number 2, my lord, his learned lawyer had sent a legal notice on 30th of January 2023, asking him, my lord, what has happened? And inadvertently, my lord, the postal receipts have not been annexed, my lord. Can I hand over the postal receipts?
And the complaint was filed after this.
Yes, my lord.
The complaint, my lord, was filed on 5th of March 2023. And the petitioner number 1, my lord, works as a constable in the Railway Protection Force. Now, my lord, my humble submission is to substantiate this allegation, my lord, of taking money to give an employment in the railway. Petitioner number 1 was implicated. Petitioner number 1 is posted in Malda, my lord. The dealing took place between petitioner number 2 and the de facto complainant.
My lord, as per the documents collected by the prosecution, this one petition number 2 is the beneficiary of the amounts. It has been transferred in this act.
And what about the petition number 1?
My lord, he is nowhere involved. My humble submission is, my lord, because then story has been tried to be made that the money has been taken to give an employment in the railways, and since, my lord, petitioner number 1 works with the Railway Protection Force.
Any material.
Material, my lord, they have the de facto complaint has supplied some letters showing that these are the appointment letters. So those has been seized.
Seized from whom?
Seized from, no, they have from the.
No,
company.
petitioner is not in custody.
No, no.
No, I am not in
Not from
custody.
the
ma'am.
Now, this type of documents can be downloaded.
So is it your submission that a civil dispute has been turned into a criminal litigation?
Yes, my lord. Grateful, your lordship. After my legal notice, when my lord, this complaint was made. Legal notice, my lord, dated 30th of January 2023. Complaint lodged in my lord, 5th March 2023.
It was given to you.
Lordship.
No, notice was given to whom?
To the defector complainant, my lord, at page.
By you?
By me, my lord.
Lawyer.
By means, yeah, by,
Yes, my lord.
by your lawyer.
Yes. On
Your
minutes of-
client is Senajit Talukdar.
Yes, petitioner number 2 before your lordship.
So this is the earlier one.
Yes, my lord, 30th of January 2023. Grateful.
The petitioners say that the complaint is absolutely false. Stop. The complainant obtained a loan of rupees, how much?
3 lakhs, my lord, at page 11.
3 lakhs from the petitioner number 2 in in February 2018. Stop. Money receipt is produced with the application. Stop. The paragraph. The money receipt stated that if the complainant failed to repay the money within 24 months, the petitioner number 2 could take legal action. Stop. Upon the paragraph, upon the failure of the complainant to repay the money, the petitioner number 2 sent a legal notice dated January 30, 2023 to the complainant herein. Stop. Soon thereafter, in March 5, 2023, the complaint was filed. Stop. The petitioners say that the complaint is nothing but an act in self-defense. Stop. The petitioner number 1 is an employee in the RPF, Malda. Stop. He has absolutely no connection with the case. Stop. He has been implicated only to make out a case that the petitioners took money from the complainant upon meeting out promise to get him a job in the railways. Stop. Paragraph, we have seen the material in the case diary. Stop. Prima facie, there does not appear to be any such material as would incriminate the petitioners. Stop. Also, this appears to be a case of a civil dispute being sought to be turned into a criminal matter. Stop. Paragraph, on an overall assessment of the material on record, we are of the view that immediate charge sheet not filed.
No.
Immediate custodial interrogation of the petitioners is not necessary so long as they cooperate with the investigating officer. Paragraph
Event officer, their arrest is 5,000 each, with 2 registers of 2,500 each. Satisfaction arresting officer, 432 compliance.
Grateful, my lord.
To appear before the to meet the IO as and when called for till submission in final form.
Grateful.
This is a good place to start, number 100. Good place to stop.
Item number 112, your lordship.
112, yes.
Yes, this matter was running in Monday street at item number 43, your lordship. Then yesterday it was 91, today 112.
Gravitational force.
Your lordship, the police can be retained, your lordship.
Written. Kalki, 100, 112, but 213 na hai.
Lordship, we have a prayer from Lordship. Lordship, tomorrow is the single day we can pick up.
Tomorrow?
So tomorrow.
Lordship, Passover matters.
Only criminal matters may be taken up tomorrow, my lord.
Criminal matters are there.
No. We have to do justice to everybody. We cannot deprive anybody. What has been done, what else?
Majority of the bar Lordship says that the bar.
Oh, sir, ma'am.
is pending.
Try to visualize that this predicament. There are many litigants who are also waiting for us. And we tried our level best to for dispensation of justice. So don't make such request.
If civil matters are not effective, not taken up, we'll call it. If they are not done, to prevent your colleagues from doing the matter.
Appeal, my lord, yes. Sometime.
Sir, we are little bit hard. We are making best possible effort to dispose of we are reaching. But for beyond the control of our some situation arises for which we cannot reach.
But be hopeful. The Honorable Chief Justice did mention in that inaugural thing that he's considering increasing the number of benches, which means the frequency of the circuit.
So we are very hopeful that the my lord will take care of your
problems.
My lord, if the bail in connection with appeal, my lord, if taken up tomorrow at the first, my lord, because not yet done till late, my lord, within the course of this circuit.
That we can do.
If that is your majority view, we can do that. But then obviously bail in connection with appeal matters will take a little longer each matter. We have to look at the evidence. So keep that in mind. We may not be able to touch bail at all.
They are also in custody, my lord.
You choose, tell us.
My lord.
Bail and
If there is difference, we will not.
438, 439.
438, 439. All right. That's all for the day.
Now you fight. Go out and
My
fight.
lord, one more thing, my lord. One more thing, my lord, before your lordship rises. Lord, yesterday, my lord, I mentioned a matter, my lord, bail in connection with appeal. That is in today's list, my lord. It is 159 item number as a mention matter. My lord, these petitioners, my lord, I mentioned that the 5 minor children, my lord, they are living the life of an orphan, my lord, at present. No one to look after. So, my lord, if can be taken
Sir,
up,
again,
some
how
precedence.
can we give priority to you and why? The other matters may
I
also be
understand,
there.
I understand.